city at this point to revoke. I don't see any new law violations. Mr. Ratfield,
This is
would not,
No.
okay. All right, so Mr. Martinez, the city's not gonna move to revoke at this time. What I'm gonna do is I'm gonna reset this for 90 days. It does, okay. Why don't we set it then end of September? We're gonna set this for the end of September. And then at that point, the city can make a decision what they want to do. You've got to get back into treatment though, because the city also could come in and say, look, we're gonna extend this another 2 years.
Okay.
Which you're still in the same boat. So, all right, so we'll put this end of September. Next court hearing, you're gonna get a court, you gotta get back into treatment. You've been to a lot of treatment. You've had no new law violations. It seems like you may be getting close to getting this wrapped up.
Yes, sir.
Okay. Any other compliance related issues? Any payments need to be made or anything like that? Okay, just get that treatment taken care of. Get proof to the court and we'll give you a court date here in just 1 second. September 24th at 8:15. You'll get a copy of this at the window outside. Okay. All right. I think that's it for today. Do I need to sign anything on those? That's just a notice here. All right. So you go to the window on the outside and grab a copy of it. Okay. But get the proof of treatment, get it to the court.
Yes, sir.
All right. Thank you. Next, thank you. Next matter is City versus Richard Melik. Melik, come forward, Mr. Melik. This is cause number 580728351. Reason I said Melik is I had a PE teacher in grade school and her last spelled the same way. Her last name, she pronounced it Melik. So,
Oh, really?
so you're Melik.
Yeah.
Okay. Mr. Melik, you're here on a DUI compliance diversion. Looks like we have an assessment and we're looking for an assessment and a victim's impact panel. Do you want to show that to the prosecutor, please?
And Margaret at Freedom Recovery, I believe it was like almost 2 months ago, she sent out emails, all the paperwork to, I think it's Daniel. That's our.
Haverco, that's your lawyer.
Yeah,
Oh.
sent it all over to him.
Mm-hmm.
And if you need me to go back down to Freedom, so she can print it out for me and bring it in, if nothing, but he has that part.
Yeah, it's always best to have it sent directly to the court.
Okay.
Because Mr. Haverco obviously moves on to other cases. He's still your lawyer, but if they can send that to the court, and is there a treatment recommendation?
She said that after it got sent, she said that after. Cause she sent it over to them, she said that, cause I did the whole thing, cause I went back there.
Mhm.
It's a great program and all that.
Yeah.
And she said that she'll send it all over there and they'll be in contact with me, so I don't know too much if she. Made it where I do need to go back into treatment or I don't.
You need to follow up with them
Okay.
and then do a release to the court. And you can get a court when you can get, it'll get you information for the court address at the window. But you're gonna have to contact the treatment folks and follow up and make sure that's getting taken care of. Okay, does that make sense?
Yes.
Okay, so we'll give them what we put on for review in like 45 days. And if you can get all that stuff in and it shows you're in treatment, and we now have the victim's impact panel proof. If we get the proof of the evaluation and that you're in treatment, if there is any treatment required, we can strike that hearing. You don't have to come back.
Okay.
Okay, all right. So 45 days out. September 10th, will that work for you? 8:15?
I'll make it do.
Okay, yeah, but hopefully if you get everything done, you don't have to come back. You just want to confirm with the court that they've received everything.
Okay.
Okay, all right, Mr. Melik, you can grab a copy of that at the window outside. Have a good morning. Thank you. City of Yelm versus Melinda Mills. Ms. Mills, come forward. This is cause number 4A398024R. This is on, again, a review its compliance on a diversion. Looks like we're again looking for the assessment and the victim's impact panel.
Okay, so I started the victim impact panel and then I ran into an issue with some kind of discrepancy about the security questions that I had put on there not matching up with the ones that I had, so I had to get that reset. So I've got that reset. Actually, they called me back this morning and told me sent me an email with all the questions that I had put initially on there.
Okay.
So I've been working on that now, and I also having a hard time trying to figure out how to pay for um the assessment, because I paid for a couple of the fines that were due, and then I thought it was gonna be like $100 or less, and that's what I had like left over. And it was like $160 where I was looking at, so I was just wondering if maybe you guys could give me some sort of I don't know, just other places that might actually have it for a little bit less of a price.
You know, does Madam Clerk, do you know of any local places that do like reduced fee evaluations?
I'm not sure which ones, we do have a list that.
Okay.
And then with some list to insurance too.
Oh, okay.
Yeah, and is that list at the window?
Yeah.
Okay, so why don't we do this? Sounds like you're working towards getting things done. Why don't we reset this out? Would 60 days be enough time?
Yes.
So if we reset this out 60 days, and just like the previous individual, if you get the victims impact panel proof, do it and get the proof here. And then also get the evaluation done and here, we can strike that hearing.
Okay.
Okay, so reset this out 60 days, please. September what? September 24th at 8:15 a.m. Will that work for you, Ms. Mills?
Yes.
Okay, so you'll grab at the window, you'll grab a copy of the hearing date, and then also you can get a list of treatment providers. And again, if you have insurance, if you have, even if it's like, some will take Apple Care, whatever, if you've got, whatever it is, you can make sure they know you have insurance.
Okay.
Okay?
Okay.
All right, so we'll see you back here on the 20th? 24th. Okay, 24th. All right, thank you. Next matter, City of Yelm versus Alyssa Pepper. No response. Next matter, City of Yelm versus Holly Riddell. This is an SOC, reckless endangerment, charge. Looks like those 2 and 50, and there have been some new law violations. This is Riddell. Cause number 580035729. Actually, I'm sorry, there have not been new law violations. Just it's a payment issue. Want to come back to that one? Okay. All right, next matter, City versus Hakeem Ridge. Good morning, Mr. Ridge. This is cause number 580864578. Mr. Ridge is present. This is a compliance diversion on a DUI. Mr. Ridge, we are looking, much like the other two, we're looking for the assessment and the victims impact panel proof. Have you done those things?
Yeah, I did my victims impact like 2 months ago.
Do we have proof of it? Do you have proof of it with you today?
And probably my email. I thought it's
Send that over just.
Okay. Okay, got it. And then, but we didn't receive any proof of the completion of the victims impact panel. We don't have proof of that.
okay. It's probably in my email because I know I did it.
What I want you to do, Mr. Ridge, is this. So when you get these things done, I always remind people, if you do it and you don't send it in or make sure, I mean, I recommend hand delivering it to the court. If you don't send it in, we don't know you did it.
Yeah.
Okay.
I put the case number and I put your guys' address in your guys'.
Yeah, but that's why I always say, make sure you bring it in. Okay. So what we're going to do is sounds like you're moving forward. We're going to reset this out just 30 days. And that's going to give you some time. Should give you enough time to get the evaluation process completed and get us proof of the victims impact panel. If you're going through, if you get all that done and we have proof of it, we can strike that hearing.
Yeah.
Make sense?
I got that.
Okay, so we're gonna reset this out 30 days and August 27th, Mr. Ridge, and you'll go to the window out there and get notice.
Is it August 27th?
August 27th, you're gonna get a piece of paper with where to on that, for that court date, okay?
All right, thank you.
But if you think you got everything in
Yeah.
before the 27th, call and the clerks will let you know. If we have everything, we can strike that hearing.
The right steps in my alcohol assessment? 'Cause I got-
They requested information,
Yeah.
so they're still in the process of finalizing.
Okay.
Okay? All right, Mr. Ridge, grab a copy of that court hearing at the window. Good luck to you. Thank you. Next matter, City versus Mary Simpson. Oh, Ms. Simpson, come forward. This is cause number 5A07285352. This matter's on for sentencing review. Ms. Simpson, this is, you provided a letter to the court,
About the electrical monitoring.
yeah, I was supposed to get a EHM for 2-3 months, but just moved out of my. So, I don't think the Nisqually jail does the weekend
Yeah.
jail. In fact, I think they don't. Yeah.
And it's. Okay, I was getting like 8 something a month
Mm-hmm.
retirement. I was looking $200 off for medical, but I still work, I have to work.
Right. So the dilemma we have, I need to look at this.
They're sent in a report to the court clerk.
Yeah, this is a DUI from December of 2025. Um. Plea of guilty was entered. You were sentenced to 60 days of electronic home monitoring. How's the treatment doing? Are you still in treatment?
Yeah, the court is getting reports from my counselor.
Mhm.
And with the internet panel.
Yeah. So I'm trying to, Ms. Simpson, it looks like, how much more treatment do you have to do?
I'm gonna go as long as I can.
Okay,
I mean, there's no set date, it's just,
yeah.
I mean, it helps when I go.
So the dilemma the issue I think we're dealing with here is there's a mandatory minimum that's in play here. Based on a driving, you had a prior DUI out of Aberdeen in 2020. Because you've already done the jail time aspect of this, right?
I did 3 days. and
Okay.
then treatment.
Okay. Why don't we do this? Why don't we reset this for 90 days out? We'll see how you are doing in 90 days. Maybe we can readdress this issue. Maybe the city makes a note, see how she's doing. Okay, so Ms. Simpson, we're gonna reset this for 90 days out. And then have you come back and we'll readdress this issue.
Oh,
So maybe Madam Clerk, if you just make notes that she owes I think she just owes 60 days EHM, right?
Yeah.
Okay. We can maybe address that at that time. We'll see how you're doing in treatment, make sure there's no new law violations, and maybe the city and can make a alternative recommendation.
oh,
Okay? All right,
thank you.
thank you. And again, no promises at this point, but,
Yeah, that's
okay.
fine.
So reset out 90 days, please. And it sounds like you're doing well. Yeah,
I feel great.
good. You look great.
Thank you.
Yeah. October 22nd at 8:15.
Oh, my grandson's birthday. That's fine.
No, I'm trying to think October. I've got a bunch of October. That's, I feel like that's one of my kids' birthdays too. But we'll have a seat. All right. And you'll grab a copy at the window. Okay, real quickly, recall City versus Matthew Byer. You guys here for court? What time? Oh, Brendan? Yeah, that's right. Okay. Gotcha. Okay. we're gonna recall, City versus Matthew Byer. This is cause number 580232463. This was a, SOC on a theft third, Mr. Radfield. 250 owed, no law violations.
City is not taking any action. So,
Close out, okay. Fire matter will be closed out. Do I need to sign an order on that or not? Okay. Next matter, City of Yelm versus Scott Johnson. Need assessment. This is on a diversion or compliance diversion on a DUI. No evidence of any assessment, no treatment. This is a Mr. Crow case.
this is, Mr. Crow is going to, unless this matter be taken, this other
Okay,
matter.
perfect. Do that. And then last but not least, City versus John Langdale. Cause number 380188272. This is a DUI. There's a new DUI with the county on deferred prosecution.
City's asking for.
5,000 cash or bond on Langdale. And then there is one more. There's a couple more. City versus Elisa Pepper. Cause number 580072282. This is a theft third, criminal trespass first degree, SOC $250, no law violations. Okay. When city takes no action, that means moving, I think it's at the end of it, right? Okay, so go ahead and close the Elisa Pepper matter. And now last but not least, City versus Holly Riddall. Reckless endangerment, SOC 250 owed on the Riddall matter.
City's asking for over an email.
500 cash or bond on the Riddall matter. Okay. All right, Mr. Haverco, we are
Yes, sir.
ready to go when you are.
We are ready.
Okay.
So let me call Mr. John Cassidy.
Okay.
Hey, John.
All right. Good morning. Are you John Benjamin Cassavant?
Yes, sir.
Good morning. This is cause number T00586-254. Mr. Cassavant is present in custody with Mr. Haverco. What are we doing with Mr. Cassavant's case today?
I anticipate he's going to be entering a straight plea to count one, of which, and then upon the course of steps of that plea, city would move to dismiss count two. I did review with him, the plea statement in particular. With this charge, there is a 1-year license suspension, unfortunately, that comes along with a conviction for this charge. And additionally, at least in the past, his commercial driver's license, while not current, he has had one. So we've discussed the fact that this will likely have an impact either on his CDL or the ability to get a CDL. I checked the box in the plea form. He and I have discussed that. So with that said, we're ready to proceed.
All right. And you are John Benjamin Cassavant?
Yes, sir.
All right. I'm gonna pull up here. Mr. Cassavant, I have before me a statement of defense on plea of guilty. Did you read through this document or did Mr. Haverco read it to you?
Yes, sir.
Okay. And what's your highest level of education?
Completed in prison in Oklahoma.
GED?
Yeah.
All right. So we have a statement of defense on plea of guilty, the hit and run charge, hit and run attended charge. You understand in this document, there's a number of constitutional rights contained in paragraph 5 that you're giving up by pleading guilty.
Yes, sir.
And this is a gross misdemeanor, means maximum penalty is 364 days in jail with $5,000 fine. You understand that's the maximum. There is an agreed recommendation here. I don't have to follow. I can sentence you up to the maximum.
Yes, sir.
And Mr. Haverco, did you discuss any potential immigration concerns?
We did, Your Honor.
All right, Mr. Cassavant, paragraph 11 contains a statement that says on July 16th, 2026 in the city of Yelm, I drove a motor vehicle, struck another vehicle causing damage and then left the scene without providing my license and insurance information to the driver of the vehicle I collided with. Is that your statement?
Yes, sir.
So as to the charge of hit and run attended alleged to have occurred on July 16th, how do you plead guilty or not guilty?
I'm guilty, sir.
Yeah, I'll find your pleas made knowingly and voluntarily. No one's made any threats or promises of any kind to cause you to enter the plea. And I'll sign that order. I'll hear from the city as it relates to sentencing. Mr. Haverco?
I asked court to follow it. He also apparently needs to get back into, is it Thurston? Just
Pierce.
Pierce County, Superior Court. He's got matters and that are important there to take care of. So I guess he's gonna be heading there, straight there as soon as he can when he gets out.
All right. How many days credit does Mr. Costavant have? Like a week?
No, I got 2 weeks, sir.
Yeah, you've been here.
Yeah, exactly 14 days, sir.
Okay. All right. Let me get into the. All right, Mr. Costavant, anything you'd like the court to consider before sentencing?
Yes, sir. I just, I need to stop doing what I've been doing, man. If you need to get all my cases resolved, and I know this is not as big as my other cases, but it's still just as bad, you know, it's charges that I just need to stop getting, and I'm sorry.
I appreciate that and I agree with you. You know, these things are, you know, it's just, I mean, obviously I assume you didn't have insurance at the time,
Yes, sir.
you know, so now the people that are the victims of this are gonna have to, you know, deal with that. Their insurance rates will probably go up. So, and also you did 2 weeks in jail, you know, on this. So, what I'm gonna do is I'm gonna follow the recommendation, gonna impose 364 days in jail, gonna suspend 350 days, give you credit for the 14, gonna impose $5,000 fine, suspend all $5,000, period of 12 months. Going to dismiss the driving suspended license third. I am going to I'm gonna reserve restitution on this case. If the city hears from either the insurance company or the victims of this matter, you know, if there's restitution, that'll be something you'll be responsible for. If they can collect from you, that's a different issue, but I'm gonna reserve that just so it remains open. If you're gonna be released, conditions of release are gonna be appear timely at all court hearings, have no criminal law violations, and don't drive without valid license and proof of liability insurance. There will be likely a license suspension. Mr. Haverco indicated he went over with you. I believe it's 1 year. Based on the plea to the hit and run attendant. So this will be reported to the Department of Licensing. On top of that, there are likely CDL ramifications as well. You understand that?
I do, sir.
Okay. All right. Anything else, Mr. Ratfield? Mr. Haverco, anything else?
Nothing else, Your Honor.
All right, Mr. Costavant, I'm going to sign this order. Good luck to you, okay?
Thank you.
Thank you, Your Honor. Your Honor, this is Justin Davis. Matter comes on for it's item number 2 on the in custody calendar for a pretrial. We're ready to proceed, and I believe he intends on entering a straight plea to counts 1 and 2, and then upon the court's acceptance of those pleas, the city would move to dismiss count 3, the controlled substance violation.
Okay, you are Justin Brian Davis.
Yeah.
All right, good morning, Mr. Davis. This is Cosmore T 00494-198. Mr. Davis is present in custody with counsel. Mr. Davis, I have a guilty plea that is showing me you're intending on pleading guilty to 1 count of criminal trespass in the 2nd degree, 1 count of use of drug paraphernalia. In exchange, if those pleas are accepted, the city would move to dismiss 1 count of controlled substance knowing possession. Is that your understanding?
Yes, sir.
Okay. You have a chance to read through this, or did Mr. Haverco read it to you, or both?
Yes, sir.
Okay. And what was your highest level of education completed?
Some college.
Some college?
Yes.
And I'm going to go over some of the points on this. Paragraph 5 contains your constitutional rights. You understand you're giving up those rights by pleading guilty?
Yes, sir.
And these are both the charges you're pleading to are misdemeanors, which means the maximum penalty on each is 90 days in jail with $1,000 fine. You understand that there's a recommendation that's contained in this between the parties. I don't have to follow that recommendation. I can sentence you up to the maximum.
Yes, sir.
And Mr. Haverko, you discussed any potential immigration concerns?
We did, Your Honor.
Okay. Well, Mr. Davis, paragraph 11 states on July 20th, 2026 in the city of Yelm, I knowingly and unlawfully without permission entered a vacant lot located at 1102 Queensview Court Northwest address. I also knowingly and unlawfully possessed a baggie I was using to store a controlled substance. Are those your statements?
Yes, sir.
So as to the charge of criminal trespass in the second degree, how do you plead guilty or not guilty?
Guilty,
And as to the charge of use of drug paraphernalia, how do you plead guilty or not guilty?
guilty.
Okay, I'll find both of your pleas are made knowingly and voluntarily, and I'll sign this order. Here from the city as it relates to sentence recommendation. All right, Mr. Haverko.
It's a great recommendation, Your Honor. Time served.
All right, Mr. Davis, anything you'd like to say before sentencing?
No, sir.
All right. Yeah, so Mr. Davis, obviously, you know, you have a ton of criminal trespass charges in the city going past the last few years. Do you feel like you're aware of where you can and can't go?
I'm just gonna try and stay out of Yelm, honestly. I mean, I got so many trespassers, it's just unreal to even be here.
It's a lot. And on this one, how many days credit do you have, Mr. Davis? How long you been in jail?
I believe 9 days.
Okay. Looks like 10. You got credit for 10 days. So I'm gonna follow the recommendation. I'm gonna impose 90 days in jail on each charge, impose 10 days credit on each charge. So you won't have any more jail time to serve. Those will run concurrent. I'm not gonna impose a fine. The conditions of release are going to be to stay away from areas, obviously the 1102 Queensview court address. All other addresses you're trespass from, and you're not to commit any criminal traffic violations. You understand that?
Yes, sir.
Okay. All right, I'll sign this order. Obviously, that third count will be dismissed. All right, Mr. Davis, good luck to you.
Thank you.
Thank you, Your Honor.
Thank you.
Mr. Johnson? This is, Your Honor, Jake Johnson. Matter comes on for an arraignment, and for the court's information, while he's not currently working at the moment, he receives about $1,000 per week in unemployment.
Okay. So, Mr. Johnson, did I hear you say that correct, Mr. Haverko, $1,000 a week?
Yes, that's correct.
Mr. Johnson have any dependents?
No.
Okay. So, Mr. Johnson, I can appoint Mr. Haverko for the limited purpose today of handling your arraignment. I will assess $100 cost to you to reimburse the city for that expense. Depending on where this goes moving forward, you're gonna have to hire your own counsel. Do you understand that?
Yeah.
Okay. Mr. Haverko, I'm gonna appoint you for today's purposes only, and I'm gonna impose $100 cost to Mr. Johnson for your representation. So go ahead with the arraignment.
Well, thank you, Your Honor. I would stipulate probable cause and ask the court to enter not guilty plea.
All right, Mr. Johnson, based on the statements of Mr. Haverko, I'm going to find probable cause for purposes hearing only to one count of controlled substance, knowing possession, one count of use of drug paraphernalia. We're going to enter pleas of not guilty to those charges. And now I'm going to talk conditions of release with the city.
City's fine with the yard release.
Okay, I can't, my system's going very slowly. So hold on one second. All right, anything else, Mr. Haverko?
Nothing else, Your Honor. Yeah, we're, we're hoping the court grants a PR release.
What does he have for criminal history? I can't see it.
June of this year, controlled substance. They used to live a drug paraphernalia. That's a word about.
In Yelm?
That's out of the district.
Okay. Has he been arraigned on that matter? Or is that a blood draw case? My bet is it's a blood draw, but
It looks like, we were supposed to be arraigned in the basic on the 28th. So I don't know. There's not that.
okay,
I don't know if they held it there as well.
okay. All right. All right, Mr. Johnson, what I'm going to do is I'm going to release you on your own recognizance following conditions. You're not to commit a criminal or criminal traffic violations. You're not to consume any alcohol or any non-prescribed drugs. Not to frequent any bars or taverns. And I want all these warrants. I don't see any active warrants. You said there were active warrants?
There is one. Sheer.
Okay. I want that warrant in Thurston County taken care of before your next court hearing out here.
I just went to Thurston County on the 28th.
Does he have a court date on that?
He does.
Okay. My bet is they'll,
I'll take care of it.
okay, he says so you're aware of these court dates then?
Yeah.
Okay, all right, just make sure you get those warrants taken care of. Again, we're imposing $100 cost on this based on Mr. Haverko, but you're gonna have to hire your own attorney. So make sure you do that sooner than later. And we'll give him an out of custody court date.
Great.
All right, next court date is going to be August 27th at 9 a.m. You're going to be given a copy of this document and see you back here on the 27th.
Okay.
All right,
Thank you. Thank you.
thank you.
This is Shane Maloney, Your Honor. Couple matters, matter ending in, item number 9, ending in 978 comes on before the court for a pretrial hearing and on the charge of crime while license suspended second degree. His current status is still suspended in the second degree, so my understanding he intends on entering a straight plea to that charge.
All right, and you are Shane R. Maloney?
Yes, sir.
All right, good morning, Mr. Maloney. We also have him on for compliance diversion for a DWLS and a DUI. Are we gonna deal with those after the plea?
Right.
All right, so Mr. Maloney, I have before me a statement of him on plea of guilty. Did you have a chance to read through that, or did Mr. Haverko read it to you, or both?
Both.
Okay. And do you feel like you had enough time with Mr. Haverko for him to answer all your questions?
Yes.
Okay. All right. So, Mr. Maloney, paragraph 5 of this document contains a number of constitutional rights. You understand you're giving up those rights by pleading guilty?
Yes.
And you understand this is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. There's a recommendation contained in this document that I don't necessarily have to follow. I could sentence you up to the maximum.
Yes, sir.
Okay. And Mr. Haverko, did you discuss any potential immigration issues?
We did, Your Honor.
Okay. And then Mr. Maloney, last but not least, this plea will result in a license suspension of a minimum for 1 year. Do you understand that? And that's completely up to the Department of Licensing.
Yes, sir.
All right. Paragraph 11 states on April 28, 2025, in the city of Yelm, I drove a motor vehicle while my license was suspended and I was not eligible for reinstatement. Is that your statement?
Yes,
So as to the charge of driving with suspended license, second degree alleged to have occurred on April 28th, how do you plead, guilty or not guilty?
guilty.
Okay. Find your plea is made knowingly and voluntarily, no one's made any promises to cause you to enter the plea. And I'll turn to the city for purposes of sentencing. All right, Mr. Haverko, anything additional?
Nothing to add, Your Honor.
And Mr. Maloney, anything you'd like me to consider before sentencing?
Yes, I actually turned myself in here, I think, when was it? Monday, I walked in free and willingly, so I can get these, these, warrants taken care of. So I
Okay,
get out, get on with my life
okay.
and go back to treatment.
Yeah, you're probably getting tired of dealing with all this.
Yes, sir.
Okay, all right. All right, Mr. Maloney, I appreciate that. I'm glad you walked in, glad you got it taken care of. That's certainly significant in this case. So, and again, this is a charge from April of 2025. And there's been no criminal matters that I'm seeing since that time. So, I'm going to go ahead and follow the recommendation. I'm going to impose 364 days in jail. I'm going to suspend 361, impose a $5,000 fine, suspend $5,000 for a period of 12 months. Conditions are abide by all the Department of Licensing rules, no criminal law violations, make all your court hearings. Make sense?
Yes, sir.
Okay, Mr. Maloney, I'm going to sign this order. And then we're going to deal with the what's the city's thoughts on the tracking? Okay, so Mr. Maloney, it sounds like the city's going to give you a shot to sort of see where you are, with this, and they're not going to take any action right now on the compliance issue. So that's a DUI and a DWS third. So that's a lot hanging over your head. So I think if it's a treatment issue, get back into treatment. Okay.
Yes, sir.
All right. Good luck, Mr. Maloney.
Thank you.
Thank you, Your Honor.
Take care of yourself.
Need this.
We'll just leave it.
How about Camden?
Hey, Garrett, Mr. Lovett. That's at 1077. I don't think we even need to have them come up, just dismiss. But we're gonna do a DCR, I think. We'll order a DCR before he's released. I think so.
So I thought it was talking about, he was telling me like, oh, like, you didn't go the wrong route, like, you should just went the wrong. That's all it's not doing. Like, they thought that's. Hey, that's very good.
Have a seat. Grab the chair. Have a seat.
Yes, sir.
This is, Your Honor, this is Camden, Somerville.
All right, this is cause number T00494209. Mr. Somerville is present in custody on for arraignment. Mr. Haverko.
And Your Honor, I already represent him on a DUI that we were in court a couple weeks ago or so, and we reset that so that he could get an evaluation. I don't know if Your Honor recalls, the parties had kind of an agreement worked out to that being an SOC, slow neg situation. I think Your Honor said that you would be willing to sign such an order, but you wanted him to get an evaluation first, so we set it over, so here we are today. So obviously he qualifies for court-appointed counsel, so it stipulates probable cause and asks the court to enter not guilty pleas, and then would like to address, release conditions.
Okay, so you are Camden Somerville?
Yes, Your Honor.
All right, it's cause number T00494209. Mr. Somerville is present in custody with counsel. Mr. Somerville, based on Mr. Haverco's previous representation, is I'm going to appoint him, reappoint him, or appoint him for this new matter. Based on his statements, we're going to find probable cause for this hearing only, and we're going to enter a plea of not guilty to the one count of assault 4th degree, one count of controlled substance knowing possession. Actually, it's 2 counts of controlled substance knowing possession. So turn to the city for conditions of release.
City is fine with the PR.
All right.
We can't hear, Your Honor.
PR.
Okay.
Mr. Haverco, anything additional?
No, that's what I was hoping the city's position would be. We'd asked for a PR as well. He indicated to me he apparently got a job with McKee or something like this,
Yes, sir.
a local like construction sort of company.
Yes, sir.
So it's a McKee construction where he's gonna be laying pipe or something like that. Labor job starting Monday. He really needs a job to pay for an evaluation just to get on with his life. So he's, really would implore the court to let him out so he can, carry on with his life, and promises he'll walk the straight and narrow here. So that's what we're asking for, Judge. Because he does need an evaluation, and that really has to happen before Your Honor will consider signing a SOC on his DUI case.
All right. What I'm going to do is I'm going to follow the city's recommendation. We're going to release them on your own recognizance. I want to put this on a, well, let's deal with conditions first. So, Mr. Somerville, you're not to commit any criminal law, criminal traffic violations. I'm not going to do a separate no contact order. This is not a DV case, but you're not to have any contact with the alleged victim in this case, individual by name of Adam. Is that going to be an issue?
No, sir.
Also I don't want you to go back to the skate park at 202 First Street South. You understand that?
Yes,
You're
sir.
prohibited from going there while this matter is pending. You make all court hearings, no criminal law violations. Not to possess any alcohol, non-prescribed drugs, or anything of that nature, not to go to any bars or taverns. Mr. Somerville, I'm very curious where this is going to shake out. So, we'll give him out of custody, court hearing. We'll want them all together.
Right.
How much in court fines do I owe right now? Cause I'm trying to get all my stuff paid off. I just want to move on with life. I'm tired of hanging out.
You don't have to contact the court about that.
All right, that's fine.
Let's leave it set for September 10th and hope there's no issues.
Thank you, sir.
Mr. Haverco, we're gonna leave it set for September 10th and
Okay.
hope and expect there's no issues. If there's any issues, we'll deal with that ahead of time.
Okay, thank you.
Thank you.
So you get out.
Thank you, sir.
Good luck, Mr. Somerville.
Thank you so much, sir. You're not gonna regret it.
Oh, I know, you'd have to ask Steve. Must be a guy. Your Honor, this is Brennan Wing. It's item number 12 on the in custody calendar. Comes on before the court for a pretrial hearing. I anticipate he's going to be entering a plea on count 1 to the amended charge of criminal trespass in the 2nd degree. Plea to count 2, possession of a dangerous knife. Enter a plea on that, and then upon the court's acceptance of those 2 pleas, the city would move to dismiss count 3 remaining after closing time prohibited
All right. Good morning, Mr. Wing. Cause number T 005113112 on for pretrial. Mr. Wing's present in custody. Mr. Wing, I have a statement of defense on plea of guilty to one count of an amended charge of criminal trespass, second degree. What's your highest level of education completed, Mr. Wing?
10th grade or 9th grade.
Okay. And did you have a chance to read through this, or did this document or Mr. Haverco read it to you, or both?
Both.
Okay. Feel like you've had enough time with Mr. Haverco for him to answer all your questions that you might have about this?
Yes, sir.
Paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand those rights?
Yes, sir.
You understand you're giving them up if I accept your plea of guilty?
Yeah. Yes, sir.
And Mr. Haverco, this is a misdemeanor, means maximum penalty is 90 days in jail, $1,000 fine. Mr. Wing, do you understand that this is a maximum penalty is 90 days in jail, $1,000 fine? There's a recommendation contained in here. I could sentence you. I could follow that recommendation, or I could sentence you up to the maximum. Do you understand that?
Yes, sir.
And anything in between.
Yes, sir.
And Mr. Haverco, discussed any potential immigration?
We did, Your Honor.
Mr. Wing, paragraph 11 states on June 27th, 2026 in the city of Yelm, I knowingly and unlawfully entered Longmire around 1:30 in the morning, several hours after the park had closed, which is a violation of the park's closing time. Upon being arrested by Yelm police, I was found to be knowingly and lawfully possession of a fixed blade knife, which I had concealed in my backpack. And sorry, I need to go back to one thing. You had the criminal trespass as well as the dangerous knife violation, which was also a misdemeanor as well. Maximum penalty, 90 days in jail, $1,000 fine. You understand I could sentence you individually to the maximum on each of those charges, Mr. Wing.
Yes, sir.
All right, so as to the charge of criminal trespass in the second degree, how do you plead, guilty or not guilty?
Guilty.
As to the charge of possession of dangerous knives in this case, how do you plead, guilty or not guilty?
Guilty.
Yeah, I find your pleas are made knowingly and voluntarily. No one's made any threatened
Yes, sir.
threats or promises of any kind. And we'll move to sentencing. I'll hear from the city.
Nothing from the city.
All right, Mr. Haverco.
Nothing to add, Your Honor.
Mr. Wing, anything you'd like me to consider before sentencing?
No.
All right. So, Mr. Wing, it looks like you have 16 days credit on these charges. Is that right, Madam Clerk? All right. I know obviously I've dealt with you before. Are there any questions about your ability to go into Longmire after closing? Do you think you're allowed to do that?
No, sir.
Okay. So did you know that when you went in?
Well, yes, I was aware.
Okay. So how do I stop you, or how does the city stop you from making those decisions?
It's a choice that I have to make.
Yeah. What I'm gonna do is, I'm gonna follow the recommendation, but I'm gonna modify the recommendation. I'm gonna impose 30 days. So he'll have to do 14 more days. 30 days on each, but they'll run concurrent. Mr. Wing, I'm gonna impose 30 days on each of these charges. They're gonna run concurrent, so you're gonna owe 14 more days in jail. Suspended time will be suspended for a period of 12 months under the following conditions. You're not to commit criminal law or criminal traffic violations, and you are to obviously not go to Longmire, and you're not to possess any alcohol or non-prescribed drugs. We're going to forfeit the weapon in this case. I'll sign a separate order to that effect, and that's been agreed by the parties. Upon release, Mr. Wing, I just, again, I hope you start making those decisions so we don't see you. Okay?
Yes, sir.
All right. That'll be all. Good luck to you.
Does that mean?
Do we have,
And Your Honor, I just learned that, Andrea Robinson, bailed out yesterday, apparently.
She did.
Okay, I didn't realize that.
Well, wait a second. Did she bail out yesterday?
Well, the jailer just told me that.
Was
so-
when does she get a court date when she came in?
Yeah, she should be.
Oh, okay. All right. Yeah, that's correct. So she did bail out.
Okay,
And then the last one we have is Michelle Lyle posted as well.
right. And then I believe the city had a motion on.
On Mr. Lovett. Yeah, we're gonna, Mr.
Lovett.
Radfield's working on that, so we'll deal
Oh,
with it. when I get-
Okay. So then I think we're done here, Judge.
Right. All right, Mr. Apico, we'll see you in a minute.
Okay.
All right. All right, now we'll go to the 9 o'clock calendar. Who do we have?
Mr. Bob,
What's his last name?
POB.
Mr. Bob, this is, cause number T 00494194 on for DUI. What are we doing today?
They're just moving this forward towards readiness or intervening pre-trial, whatever the court prefers. About a month out.
Okay,
Not exactly. Again, unavailable 27th.
well, where are we at with this?
Should be through October.
Some ratings on July.
Okay. July 13th, we're now July 30th. Put end of August, fine with that?
I'm with that.
Okay, it's just set up for pre-trial. We'll deal with trial stuff at the next hearing.
And I can't do 27.
September 10th.
Yeah. That much.
When's speedy trial run?
This is the first appearance after rain and on July 13th.
Okay. All right, next, would you say September 13th?
And
September 10th. All right, September 10th at what, 9?
Yes.
All right. Mr. Bob, next court date is going to be September 10th at 9 a.m. All prior conditions remain in effect. Stay in touch with your attorney and see you back here on the 10th. Okay?
One thing to address, Mr. Bob, it looks like signed a declaration of non-driving. He has a vehicle now, wants to know if he can switch over to the interlock. And how would we do that? Rather than non-driving declaration.
So all he'd have to do is if he gets the ignition interlock in his, so there was a pretrial condition for ignition interlock. If he gets the ignition interlock installed and just provides proof, that'd be sufficient.
Okay.
Okay, the main thing, Mr. Ambrose, or Mr. Bob, sorry, is if you drive, you just gotta make sure, like, you can't go drive my car because I don't have ignition interlock in it, right? So the condition is any vehicle you drive has to have ignition interlock. If you then choose not to drive, that's like your attorney's saying, you don't have to have one in, but if you do drive, you have to have ignition interlock in a vehicle. So we just need proof of install. Okay?
Yes, sir. Thank you, Your Honor.
All right, thank you. We'll get you a copy of the court hearing at the notice of the window. All right, thank you. Come on up, Dan. Is this Mr. Bray?
This is Mr. Craig. I had 2 on this morning,
Yep.
Your Honor. Mr. Johnson.
Okay, deal with the Bray matter first. This is cause number 6A0232645. Joseph Travis Kilakila. And there's something cut off Bray. Okay, good morning. cause number 6A0232-645 on with DUI with Mr. Crow. Mr. Crow, what are we doing with this case today?
Well, good morning again, Your Honor. Today we're entering a stipulated order of continuance. We would set this matter out for 2 years.
Yep.
At the end of 2 years, provided Mr. Bray follows the requirements that are in the stipulated order of continuance, the case will be dismissed.
Okay. Mr. Bray, because you're represented, I don't spend a ton of time on these things. I'm assuming Mr. Crow went over this contractual nature with this, the rights you're giving up, et cetera, et cetera. Any questions you have for Mr. Crow? All right, anything additional from the city on this? All right, so Mr. Bray, this is a 2-year stipulated order of continuance on the charge of DUI. Conditions are going, and the maximum penalty on that's 364 days in jail, $5,000 fine. You're going to pay a $250 monitoring fee. You're gonna stay out of trouble, no criminal law violations, not to drive without valid license, liability proof and proof of liability insurance, not to be in physical control of the vehicle above 0.08 or with a THC concentration of higher than 5 nanograms per milliliter. No alcohol related infractions. Don't refuse to submit any breath tests if asked to do so by law enforcement, the court, or a treatment provider. Alcohol assessment within 90 days. Start treatment within 30 days of that completion. If any is required, complete a victim's impact panel within 90 days. And I don't know if how early you were here, but we had a bunch of people on for review this morning. Several of them were on SOCs, which is what you're on. And they were here, they're brought back to court because they hadn't gotten us proof of their assessment and the victim's impact panel. So make sure you get all that stuff timely, get it to Mr. Crow. He'll make sure we get it. Okay. All right. Anything else from the city?
No.
All right, Mr. Crow.
Nothing further.
All right, Mr. Bray, I'll sign this order and you'll be able to grab a copy with your attorney at the window and set up fine payments. And was this, sorry, at the end of this, was it amended? Okay. Amended to end of 2 years, an amendment to a
Dismissal.
dismissal. So it's a dismissal. After 2 years, if you're good to go, this matter gets dismissed. Okay. All right. It's a good deal. Good luck to you, Mr. Bray. Okay. And then Mr. Johnson, Scott Johnson, is he going to be here?
He's not going to be here. We've agreed to a continuance.
Okay.
He left treatment in order to seek treatment from a provider that was covered by his insurance company.
Good.
They're making him get a new assessment, so we just need maybe till the 27th to make sure that that assessment gets filed with the court so we can show that he is actually in treatment.
Okay. Any objection from the city?
No objection from the city.
All right. This is cause number 5A03123116 and 5A03123117. Scott Johnson, represented by counsel. Reset to when?
I heard the 27th. If there's still space available on the 27th, why don't we do that?
He was open for the 27th, September. August or September?
August.
August. Oh,
It shouldn't take him too long to get an assessment.
yeah. Count, there is he gonna be under the 830s? 815s. There we are. It's
I don't, but I would sure prefer 9 a.m.
August 27th, 9 a.m. All right, we'll trust you'll get notice to Mr. Johnson.
I will give notice to Mr. Johnson.
Thank you. All right, take care. Yep. Okay, okay. Okay. Is there Kevin Grant present? No, okay, let's call up Mr. White. Do you know what we're doing with Mr. White's case today? Okay. Not Mr. White's case, but it's Mr. Grant, Kevin Grant's the defendant.
Good morning, Your Honor.
Good morning, Mr. White. How are you?
I'm good. How about yourself?
Good. We're here on cause number 6A02056615, City of Yelm versus Kevin Dwayne Grant. Are you appearing for Mr. Grant today under 3-4?
I am, Your Honor, and I've uploaded a motion to continue on that. Mr. Grant's in the process of finishing all of his affirmatives, and I need some additional time to chat with the city about this one. I selected the first setting in September. Unfortunately, those August dates don't work for my calendar, but I'm hopeful we'll likely be able to resolve this at that date.
Okay, any objection from the city? All right, Mr. White, next court date is gonna be September 10th at 9 a.m. And I'll trust you'll get notice to Mr. Grant.
I will, Your Honor.
Sign that order. Do you have any other matters today?
That's all I had. Thank you so much.
All right, good rest of your day.
You as well.
Wilson, okay. Is there a Michael Wilson present? All right, Mr. Wilson, why don't you come have a seat? All right, good morning, Mr. Kleiner. How are you?
Very well, Yara. Good morning. How about yourself?
I'm good. I have, this is City of Yelm versus Michael J. Wilson, cause number 6A0006643. Mr. Wilson is present in court. Mr. Kleiner is present via Zoom. What are we doing with Mr. Wilson's case today?
Yara, good morning again. We're asking for one more continuance to September 10th. Mr. Wilson does have he was working out of state, so it took him a while, but he does have his affirmative scheduled in August, starting on August 12th. I've had multiple communication with Mr. Redfield. I do anticipate this case getting resolved, and we'll be there in person on September 10th, and hopefully we can wrap this up.
Any objection from the city? All right. So Mr. Wilson, we're going to reset this matter to September 10th at 9 a.m. You get a copy at the window. Make sure you stay in touch with Mr. Kleiner. Sounds like things are moving forward. Hopefully we'll get it resolved on the 10th. Okay, I'll sign this order and you can grab a copy at the window.
Thank you, sir. Thank you very much, Yara, and thank you to the court staff, and thank you, Mr. Redfield.
Yep. Have a good rest of your day, Mr. Kleiner.
Thank you, you too.
Okay. All right, Mr. Wilson. Have a good day. Anybody else online? Okay. We do have one, Mr. Burklow. Come up, have a seat. So Mr. Burklow, this is cause number 6A0002347. Mr. Burklow, when you were here for arraignments, I believe I did not find you eligible for court-appointed counsel. So you were tasked to either represent yourself or find your own counsel. What is the status of that?
I'm requesting a continuance to get my counsel.
Okay.
It's quite a lot of money and I just started a job when we were here last time.
Okay.
So I'm working and I'm saving up money for this.
Okay.
For this council.
What's the city's position?
City is fine with the continuance.
Okay. How are we on speedy, Madam Clerk?
So
I wouldn't want to kick it out very far then. Mr. Burklow, what we could do is probably put this I mean, are we pretty close? I mean, I wouldn't want to go, I could go to August 13th to reset this. Because, or we need you to do a waiver of speedy trial.
Okay.
If you're willing to do that, I could have the city prosecutor put together a waiver that would basically, you have a right to a trial within 90 days of the date of your arraignment. We can reset that. And if you were willing to reset that, if we put it, let's say we put it August 27th, if you did a waiver that restarted the 90 days on August 27th, I'd be comfortable with that.
Okay.
Is that something you're willing to do?
Yes, sir.
Would the city mind putting together okay, so go ahead and have a seat, Mr. Burklow, and I'll have the city, so we'll plan on setting it for the 27th of August. And we'll just, and if you could just do a waiver and then he can.
I'm putting it together, Madam Clerk, unless you're already. Yeah. I'm putting together the motion.
Okay. We'll come back to that one. Is there a David Langston, Matt, present? Come up, have a seat. David Eugene Langston, cause number 5A0915781. Mr. Langston, I'm showing this is on for pre-trial. Are you represented by counsel?
Yeah, the gentleman.
Mr. Haverco? He's on his way over. So just go ahead and have a seat. Sorry, I'm just trying to get folks up. Okay. Oh, did he not qualify? Mr. Langston, come forward again. So Mr. Langston, when you were here for arraignments, you were, what I did at that time is I appointed, are you working?
No, sir.
Okay,
At the, when I first got the charge, I planned on running away from it.
okay,
And I then recently got back in contact with my grandmother, and I've had a lot of other court cases. She's helping me financially with getting all of these taken care of. I just recently got my license, I got insurance and stuff like that. And I'm just trying to start back from ground zero. So like originally, I didn't even plan on taking care of this.
I got you, I got you. So let's do this. Are you working right now?
No, sir.
Okay, so you're getting things taken care of.
2 days a week, Monday and Wednesday.
Got it, okay. So what I'm gonna do is we're gonna go ahead and appoint Haverco. And so we're gonna appoint the public defender. And what we're gonna do is we're gonna reset this matter out into August, probably August 27th. That work for you?
Yeah.
Sounds like you're moving forward, doing
Yeah.
things. Perfect, great. The more you can get done, so we're gonna give you a notice for August 27th. All prior conditions remain in effect. And then what we're gonna do is you're gonna give information on how to contact Mr. Haverco. And we'll make sure he gets your file and everything's up to speed, okay? Any questions about that?
What address do you guys have on file? I just want to make sure it's the, okay, that works for me. Thank you.
Okay. All right, let me, yep,
And you guys want me to go to the desk?
yeah, you'll go to the window. All right, Mr. Langston, thanks for coming in. And again, Mr. Haverco's information will be on this form, so give him a call. Okay. Hold on one second. I want to get the order on Langston signed. Do I need to sign the order? Oh, okay. Who do you have online? Okay, let's pull them up.
Oh, it was like, you want to be free for dogs and feet. Like was there and then stuff.
Okay. Okay, but he's gone now. You want to recall the Burklow matter?
Yes.
Okay, Mr. Burklow, come forward. All right, you're Timothy Burklow?
Yes, sir.
All right, Mr. Burklow, we had a brief conversation earlier on this matter. This is cause number 680002347. You are in the process, at your arraignment, I found you did not qualify for court-appointed counsel beyond arraignment purposes. You've indicated you're working on getting a retained counsel, that you're working diligently on that.
Yes.
So as of right now, you're still pro se. You've requested to continue this matter for a little bit, to gain a little more time to get a court appointment or to hire attorney. And so with that, you had a brief off the record conversation with the prosecutors regarding resetting this matter to August 27th to give you some time. But along with that, there will also be a waiver of speedy trial. And that waiver of speedy trial will restart your 90 days for the time, for the window of time for the city to be able to give you, to get you to a trial, which will restart on August 27th. Do you understand that? And do you want me to sign that order?
Yes, sir.
Okay. All right, Mr. Burklow, I'm going to pull up the motion to continue, resetting this matter to August 27th, 2026. There is a waiver of speedy trial sets a new commencement date of August 27th, 2026, which makes the expiration date November 25th of 2026. You've authorized me, you understand that, and you would like me to sign that, and I will sign that order. Okay. So you'll grab a copy of this at the window. When you hire counsel, make sure they're given a copy of this court date so they know the timeframes we're dealing with, and we'll go from there.
Also, I was talking with the prosecutor, when I came to court that first time, they gave me the no contact order with the correct initials. And then a few days later, the police showed up and gave me the same no contact order with the wrong initials, saying that this one was the right one, but it is not.
That's two different names. They go on, and so we ended up having to redo that. The first one did not have the legal name of the money that is protected.
Okay, so what I'm understanding is
That's, it's just.
the protected party goes by a couple different initials. And so, main thing is, do we know who do you know who?
Yeah.
Okay.
Yes, sir.
And you know you're not to have any contact with
Yes,
this
sir.
person. So at this point, that person, you are prohibited from having contact with that person.
Yes.
Okay, okay. All right.
I just wanted to,
Yeah, I appreciate that, but the clerk just explained that there was a naming issue. So, all right, any other issues?
no, sir.
Okay, grab a copy at the window. We'll see you back on the 27th. All right. Mr. Naus?
Good morning, Your Honor.
Morning, this is cause number 6A0006649, City of Yelm versus Sky Talalele. Are you appearing for the defendant today?
I am, Your Honor. I'm appearing, I believe Ms. Elena Stevens is the attorney of record. She is an attorney at my law firm. We are appearing pursuant to Rule 3.4 for Ms. Tualele. I had recent contact with her and authorization to appear on her behalf, as well as authorization to recommence speedy trial. We're asking the court to continue this matter to, I believe, September 10th. We've loaded a proposed order, and we anticipated disposition on that date. We would just ask for some time to coordinate our calendar so that we can be there in person.
Okay, any objection from the city?
No.
All right, okay, Mr. Naus, we're gonna reset this matter to September 10th. Due to ongoing negotiations, I have a speedy trial waiver with a new commencement date of September 10th, which would make the expiration date December 9th. With your blessing, I'm gonna sign that order.
Thank you very much.
Any other matters today?
No, thank you.
Okay, have a good rest of your day. We'll see you back on the 10th.
You too. Bye.
Take care, bye-bye. Love it. Do you wanna, is there an order in there?
There's an order.
Okay. And did you put in there to order a DCR? I think didn't they want a DCR before you?
Remember what? I didn't include that in the order of dismissal, but I probably could.
Okay. Thank you. Excuse me. Yeah, opinions required as to whether tenant should receive it or so come out vouched by DCI's opinion based on it. Oh, it says they do not, so he does not, so they're not recommending a DCR. Okay. All right. I'm gonna sign the order on Lovett. And I'm not gonna order a DCR. Will you, I mean, this is being dismissed pursuant to a 1077 evaluation. Do you put that in the docket notes?
Yes.
Okay, great. Okay, all right, I've signed that.
Will be just on our screen, so that way it'll show up.
Yeah, yep. Mr. Haverco, just so you know, I just signed an order on Mr. Lovett. So we're dismissing that. It's a standard dismissal without prejudice. did not order a DCR based on the evaluation. So I just asked the clerk will indicate on our docket notes that it's dismissed because of a 1077. So just so anything, do you see anything procedurally wrong with that? Okay, all right, thank you very much. So I signed that order, so we'll just make sure we get that over to the jail. Okay, Mr. Haverco,
She's declined.
okay, then let's move forward with Mr. Haverco then at this point. You have any cases ready?
I might.
Okay.
So turning to the 945, do we have a Maria Lynn Bayard? Okay. Do we have I don't see Kevin Bingaman. I know him on site. I don't see him.
Okay.
And he's not mine, but I know Timothy Higgins is on the 945.
Yeah, he was on the same earlier. But now he's not.
Okay. And then there was also on the 945, a Zachary Andrew Christoph Kuzior. Why don't you come on up?
This is 945.
Yeah, it's 945. He's got a couple of matters and so he failed to appear last time and.
Gotcha. All right, you are Zachary Andrew Christopher Kuzior?
Yes, sir.
All right, Mr. Kuzi, is it pronounced Kuzior?
Hoosier.
Kuzier, all right. Cause number 580657409. Mr. Kuzier is here on a warrant quash. Why'd you miss court?
I was in jail.
Okay, fair reason. Did all that get resolved?
Yeah.
Okay. All right, Mr. Haverco, we have Mr. Kuzier present. Do we want to just reset this on for time?
Just to reset it, and let me just confirm with him his number. Do you have a phone number?
Yes.
What is it?
253
Okay,
820
okay,
7551.
okay, great. And then we'll talk.
And so, Mr. Kuzier, this is going to quash the warrants that we have. You have 2 warrants in Yelm. You also have an active warrant in Olympia.
Yeah.
So-
We'll work on that one after this.
Yeah, okay. Get that taken care of. As part of the conditions of release here, I'll add that to it just to take care of that. All right, but it looks like you're doing good.
Yeah.
Feel good?
Yeah,
Good.
going treatment, got a place over my head and I was wondering if I could get verification that you guys are quashing the warrants and stuff.
Madam Clerk,
We don't really have a verification, it's just gonna show up the system.
why don't you put on the release, put on his new court here, just add in there that warrants, the Yelm warrants are quashed. So it'll be something in writing.
Thank you.
Okay, so I'm gonna modify the conditions of release just to make sure you get that Olympia warrant taken care of. Do I need to sign anything on that?
No, it's-
Okay, just that'll be on the hearing notice. So that'll be, what's the next court date? August 27th at 10 a.m. Okay, you're gonna copy the window. And we'll see you back here on the 27th. All right, good luck.
Thank you, Aaron. Next matter on the 945 would be Jeremiah Marshall Ray. He is here. He also has a new case on for, he has a pretrial he had failed to appear on, and then apparently an arraignment he had failed to appear on as well, Your Honor.
All right, and you are Jeremiah Marshall Ray. All right, good morning, Mr. Ray. You're here on 2 matters, pretrial cause number 580312327, and an arraignment on a cause number 580657398, dumping solid waste greater than 1 cubic yard. Mr. Haverco, it looks like you already represent him on the pretrial, so I'll appoint you on the arraignment as well. Why don't we deal with the arraignment?
Okay, thank you. So as to the arraignment, Your Honor would stipulate to probable cause and ask the court to enter not guilty plea.
All right, Mr. Ray, I appointed Mr. Haverco for this new charge. We're gonna find probable cause purpose of this hearing only and enter a plea of not guilty. We'll discuss,
I don't even know what.
hold on, Mr. Ray, hold on. So, we're gonna deal with the warrants. Warrants are gonna be quashed based on his appearance. And we've entered a plea of not guilty on the, solid waste charge. And then we have the pretrial. What would you like, what's your preference, Mr. Haverco?
Just ordinary course.
Okay, so Mr. Ray, what we're gonna do, we appreciate you coming in and taking care of the warrants. Mr. Ray? So I appreciate you coming in, taking care of the warrants. We're gonna give you a new notice to come back. And you're gonna get a copy of that at the window. Mr. Haverco, the gentleman sitting next to you is your attorney. You're gonna be given his phone number. You can reach out to him anytime. Mr. Ray?
I'm at a point, you guys need to reach out to me. I've crossed the street and every one of my rights.
Okay, Mr. Ray, do you have a phone number? Do you have a phone number that Mr. Haverco can get?
You have a phone number? Just right here, just right here.
May I?
Yeah.
Mr. Ray? Mr. Ray? We're gonna give you a piece of paper that's gonna give you another court date. Mr. Haverco, did he write down a phone number for you?
He did.
Okay, so Mr. Haverco is gonna be in touch with you before the next court date. And hopefully we can get this resolved at the next court date. I'm looking at your,
No one even have any copy. I'm gonna take this to trial.
I got it. That's Mr. Ray. I'm gonna stop you. Hey. Mr. Ray, I'm gonna ask you to come back here and sit, please. Are you gonna refuse to come back in here? Okay. Okay, take a minute. Let me know when you're ready, because all we're gonna do is we're gonna give you another court date. So just sit out there, relax. And I appreciate you recognizing that if there's an issue that's upsetting you, that you separate yourself. So what we're gonna do is we're gonna give you a court date that's gonna be on a piece of paper that you're gonna get at the window to your left when you go out the door, okay?
Yes.
Okay. Mr. Haverco, does he need to sign anything?
Well, he doesn't,
I'm not talking nothing.
okay.
Okay, okay. All right, Mr. Ray, that's all for, what's this court date gonna be? August 27th at 11 a.m. You'll get a piece of paper with that date on it. Okay, thank you, Mr. Ray. Good luck to you.
So.
Do I need to sign that?
Yes, it's a.
Okay.
Is there a, I don't know who all is here yet. Is there a Gerald Christopher here? Okay. I guess they're not really required to be here yet because it's not 10 o'clock actually.
Right.
Oh, here's Mr. Bingaman. Okay.
Hold on one second. So Mr. Abercorn, Mr. Ray, just keep us apprised as to the interactions with him.
Okay.
Okay.
If we could go back to the 9:45, Your Honor, Kevin Bingaman is now here.
Oh, Mr. Bingaman, you may have a seat.
I guess he had failed to appear at his last hearing. Do you have a phone number now? Or
Yeah.
what is it?
360-280-1969.
1969. Okay. Okay. So this is to be a first appearance.
City of Yelm versus Kevin Porter Bingaman. Good morning. Cause number 4A398023R. Why'd you miss court? Why'd you miss court?
Transportation.
Okay, did you call?
I did call and it was still, they said that there's no Zoom and everything, so it
Okay.
was, yeah.
Are you living locally or where do you live?
I live at least 5 miles out of bus range and everything up
Okay.
on Bald Hills.
Did he call? Was there notes of him calling? I trust that you called, but a lot of times, if somebody calls and they can't get here, normally we don't issue a warrant. Which
Yeah,
tells me maybe we didn't get the message or something, so, we'll give you the benefit of the doubt this time, so we'll quash the warrant, Mr. Bingaman. Again, you've got Mr. Haverco's phone number, get a hold of him. And we're gonna reset this matter, prior conditions all remain in effect. What court date are we looking at? August 27th at 11 a.m. All right, and, let me take a look at something here. Okay. Well, all right. Yeah, got it. So this is this is a pretty old charge, so we need to get this case moving forward. Okay,
This is just for the court's information. It was one of those blood test cases.
yeah, oh, gotcha,
Yeah,
okay,
so that's why
got it,
it was
okay,
refiled.
got it, okay. All right, Mr. Bingaman, we'll see you back here on the date that'll be on the paperwork, and stay in touch with Mr. Haverco. All prior conditions remain in effect. Good luck to you. Okay.
Thank you. See, back to the 10, I think Salvador Fernandez is here. If he is, I'll have to talk with him. Are you Salvador? Yeah, just remain seated. Just go ahead and remain seated. I haven't had contact with him, so I'll have to.
I've got Miss Alt online. If you want to give me a few minutes, we can take.
Well, yeah, go ahead and take that minute.
Okay.
Let me just see who else is here.
Okay. Good morning, Miss Alt.
Good morning, Your Honor.
How are you?
Good, how are you?
Good. You are here on one of your cases is are you here, Sean Ramirez?
Yes, and McGathy.
Okay. Any preference on which one you want to do first?
We can start with Ramirez.
Okay. Are you appearing for Mr. Ramirez today?
I am appearing for Ms. Ramirez.
All right. What are we doing?
Your Honor, we're asking to set this matter for readiness and trial.
Okay. Bench or jury?
Jury.
Okay. So, Ms. Alt, when we do that, what'll happen is these cases, Yelm contracts with Thurston County District Court, which you probably already know. So those jury trials are then it goes into the district court system for setting of the trial and setting the jury and readiness and all those kind of things.
Okay.
Okay. Do what?
This is, let's see, first.
How much?
June 9th was the arraignment.
Okay. And then have there been, so this is the first pretrial since arraignment? Okay. Well, what we'll do is, on Ms. Alt, I haven't heard any discussion about a waiver. So is there any discussion about a waiver at this time?
No, so is this court not able to provide the dates since it goes through Thurston? I was planning on just setting it within Speedy.
Correct. We send it over to the county, then the county sets the dates. Right now, we have arraignment date of June 9th. And this is pretty late pretrial for a first pretrial. So we're halfway-ish into Speedy already. So that's gonna put district court on a bit of a time crunch to get it set.
Okay. My concern is just there's a no contact order and it's a mother-daughter and they're not able to communicate. So I'm just not wanting to waive given that situation.
Okay. All right. Well, why don't we'll just have to set it and get over to the county. Okay. So we'll set it and get it over to the county. There won't be any dates today. You'll receive those from Thurston County.
Okay.
And, we'll go from there.
Okay, thank you.
Okay. And I'll sign. Do I need to sign an order on this even? Okay, discovery motions. Oh, okay, gotcha. So Ms. Alt, just wrote, this is sort of a mini omnibus order. Any custodial statements that the city's aware of?
No.
Okay. I'll put no custodial statements.
And so as far as am I still working with the same prosecutor, or is this then contracted out to one of the Thurston prosecutors?
I think it's still Mr. Ratfield.
Okay, okay.
Yeah. Is there a 911 tape anyone's aware of? From the city? Yeah.
I believe there are several, but I'm not sure if the city is trying to have those be admitted or not.
Okay. What I'm gonna do is I'm just gonna put a hearing is requested to address the admissibility of 911 tapes, but you guys can figure that out. Okay. CR, any 3-6 motions?
No.
No, okay. Or what, any safely off the roadway or anything?
No.
Okay. Okay, well. I think I butchered this order appropriately enough, so I'll sign this order. It'll get sent over to the county, and then you'll get dates from the county, and then obviously still stay in touch with Mr. Ratfield if it can get shaken out.
Thank you.
All right, thank you. And then the next one you have, Ms. Alt, is Christina McGathy.
Yes, Your Honor. I've reached out a few times to the prosecutor and haven't gotten a response, so my inclination is to set this for trial to get it moving, but if the prosecutor can just send over an offer and we can do some negotiating, then I'm happy to set this over.
We'll set it over and I'll respond to you now.
Thank you.
Okay, so this is City of Yelm versus Christina McGathy. Ms. Alt's appearing on behalf of Ms. McGathy. This is cause number T00511304. My understanding is we're gonna reset pretrial.
Yes, Your Honor. And I had yesterday uploaded a trial set so I can trash that and put it into pretrial order here. I'm just logging into O Courts.
Okay. And what dates are we looking at? What date do you want for pretrial?
So I'm sorry, they're always Thursday mornings.
Yeah, we've got August 13th, which is probably pretty quick. August 27th,
What are the September dates?
September 10th, and September 24th.
10th is fine, Your Honor.
Okay, September 10th at we will need a speedy, if we want to go that far out, we'll need a speedy trial waiver.
That's fine. I'm just trying to get here into the system so I can.
Okay, Ms. Alt indicated she'd do a waiver. So it'll be September 10th at what time? 9 a.m. And just make a commencement date, that date, I guess, to make it clean.
Okay, I'm adding that document here.
Any comment, any objection from the city? Okay. Okay.
And I just wanted to, she does not reside in the state, so I just wanted to note on here and make sure that if we have a resolution that she has permission to appear
Zoom's okay.
via Zoom.
We what? We have a Yelm address for her, so is there an updated address you can provide the court later?
Let me see if I have that right now. No, but I'll get that from her.
Okay. All right, September 10th, 9 a.m.
I'm filling out that waiver right now. It should be ready here in just a moment.
Got it.
Okay, I've signed for defendant, indicating 3.4, and then I've signed for me, so that should be in there.
Got it. All right. Next court date, September 10th, 9 a.m. Speedy trial waiver, commencement date, September 10th, expiration date, December 9th. No objection from the city, and I will sign the order. All right, Ms. Alt, anything else for today?
No, thank you.
All right, have a good day.
You too.
Okay. All righty, Mr. Haverco, back to you.
I think we're back to the 9:45, or sorry, back to the 8:30. This is Andrea Robinson. She's on the 8:30 calendar, but she bailed out and we're here to resolve the matter. Matter comes on for a pretrial hearing.
Okay, you're Andrea Linnea Robinson, cause number 680021965. You said this was on the 8:30 calendar?
Yeah, it just was there because that's where she was at the time when the calendar was generated, but then she bailed out, I think, yesterday.
Okay, all right, what are we doing with and good morning, Ms. Robinson. What are we doing with Ms. Robinson's case today?
I've gone over a statement of defendant plea of guilty with her. I anticipate she's going to enter a straight plea to the interlock violation. Upon the court's acceptance of the plea, city would move to dismiss the suspended driving third case.
All right, and you are Andrea Robinson?
Yes, Judge.
All right, Ms. Robinson, I have before me a statement of defendant on plea of guilty to one count of operating motor vehicle without ignition interlock. That is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. Have you had enough time to read through this document with Mr. Haverco? And did he answer all your questions that you might have? And importantly in this, you understand that there's the constitutional rights contained in paragraph 5 that you're giving up by pleading guilty?
Yes.
And you understand that there's, again, the recommendation that's contained in this, but I could sentence you up to the maximum. Okay. And discuss any potential immigration concerns.
We did, Your Honor.
All right. So Ms. Robinson, paragraph 11 states, on February 9th, 2026 in the city of Yelm, I drove a motor vehicle without an ignition interlock device as previously ordered by the Washington State Department of Licensing. Is that your statement?
Yes, sir.
So as to the charge of operating a motor vehicle without ignition interlock, how do you plead, guilty or not guilty?
Guilty, Your Honor.
Okay, I'll find your plea is made knowingly and voluntarily. And no one's made any threats or promises of any kind that cause you to enter the plea, and I'll hear from the city in terms of sentencing.
Nothing from the city, Your Honor.
Mr. Averco?
It's a agreed recommendation, Your Honor. She's just not working right now. And so we would ask the court to consider not imposing any financial obligations.
Okay. Ms. Robinson, anything you'd like to say before sentencing? You don't have to say anything if you don't want to.
Oh, Your Honor.
Okay. I am showing a warrant out of Grace Harbor.
She's aware.
And it doesn't look, still don't have a Washington driver's license. Is that right? Okay. All right. So Ms. Robinson, I'm going to follow the recommendation. Okay, I'm going to follow the recommendation. I'll dismiss the DWS third. I'm going to impose 364 days in jail, going to suspend 359, give you credit for 5 days served on that. Okay.
Yes, Your Honor.
Impose $5,000 fine. I'm going to suspend all $5,000 for a period of 12 months. City's thoughts on the probation fee of $250.
I mean, city would like to see it imposed and if, if circumstances continue, then Ms. Robinson can come back and repetition the court, but.
Yeah, Ms. Robinson, you seem like somebody that's probably employable to me. What I'm going to do is I'm going to leave the $250 in place. You can make payments on that. If something changes, towards the end of the 12-month probation, if it comes up and it hasn't been paid, if you want to maybe seek to talk to the court again about that, but I'm going to leave the $250 imposed at this point. And that's just so the city can recoup some costs related to this process. Okay. You're getting a pretty good deal in this. Mr. Averco did a great job. So, okay. All right. No criminal law violations, appear timely at all court hearings, do not drive without valid license and proof of liability insurance, and you need to comply with all the conditions of the Department of Licensing. Okay. Okay. I'll go ahead and sign this order. And good luck to you. Okay. All right.
Good luck. Next matter on the 10 o'clock would be Daniel McGuire. Why don't you come on up, Daniel? And my hope is that in light of the fact that Mr. McGuire's suspension status is now that of third degree, the city might have a motion.
City's moving to amend to no ball in the second. With a recommended fine of $150.
Okay,
And to which we would admit.
okay. Let me get to that one. You are Daniel K. McGuire? All right, good morning, Mr. McGuire. So I have a note here. Yeah, it looks like it's currently third degree. Is there a path to get your license
Yeah,
back?
I've been looking into that. I have to submit a document to Centralia to where they'll sign the ticket.
Yeah,
And turn it in, so they just put me as an FTA basically.
yeah,
So I have to submit some papers, file some paperwork with them, and then they'll release it to where I can go get my license back and be valid, get my license.
okay, good. All right. So based on the city's motion, the city's amending this to a no valid operating license with ID and imposing a fine of $150. You can just get the copy of that at the window and you set up fine payments. As long as you're making fine payments here, it won't have any effect on your license. Okay? All right. Good luck to you, Mr. McGuire. Do I need to sign anything on those? Remind me. Okay. That's right. That was on the 10 a.m. Got it. Okay.
I'll sit there because we don't really have. Yeah, but I'll call.
Okay, who do we have here?
Is
Robin Palmer?
Yeah, this is Robin Palmer.
All right, good morning, Ms. Palmer. Cause number T 004999703. Ms. Palmer is present out of custody counsel.
Yeah, matter comes on for the court for a pretrial hearing on the charge of theft. Parties have reached an agreement that being a stipulated order of continuance, which she signed, the matter to be continued for 12 months on the condition of no new criminal law violations, $250 probation fee, and
All right.
dismissal if she complies.
All right. And you're Robin Palmer? All right, Ms. Palmer, I'm not going to spend a ton of time going over these because these are a agreement between yourself and the city. Do you have any questions that Mr. Haverco didn't answer? Okay, what's the end result of this if Ms. Palmer suggests, if she's successful? Dismissal?
It's dismissal.
Okay. Looking at your record, you don't have any similar charges, so hopefully this is a one-off and it won't happen again. All right, Ms. Palmer, we're going. What's that? Oh.
It doesn't come from actual jurisdiction.
Oh, oops.
I think it must have saved it.
Looks like it's a 12-month SOC, is that right?
Yeah, I'm telling you, I think it got saved and saved it.
Thank you. And it resulted in dismissal?
With the maximum jurisdiction and.
Yeah, it's in there now. I see it. All right. So Ms. Palmer, 12 months, so long as you've stayed out of trouble, paid the $250, this matter comes up for automatic review. If you're successful, it's dismissed. If you're not successful, what happens is the city moves to revoke, and this matter is then brought back to myself or whatever judge is sitting here, and your guilt or innocence would be decided by the reading of the police reports. Understand that? Okay. All right, I'm gonna go ahead and sign this order. You can get a copy at the window. You can and talk to them about setting up the fine payments. All right, good luck to you.
Yeah, just go have a seat and you guys can meet together. So the next matter is gonna be, we're gonna jump to the 11 o'clock because Ms. Monahan is the co-defendant.
Okay.
And they came together, so why don't you come on up? Go ahead and sign here.
You are Lisa A. Monahan.
It works.
Yes.
All right, this is cause number T 004997002. Ms. Monahan is present out of custody with Mr. Haverco.
And this is an identical agreement, Your Honor.
Okay, so Ms. Monahan, same things I talked about with Ms. Palmer. Do you have any, now, Ms. Monahan, also a little bit different here. Your case, there's I imposed based on some economic issues. Required you to pay $200, reimburse the city for $200 for the court-appointed counsel fees. Has that been taken care of yet?
No.
Okay, so that'll be part of this SOS, okay. Thank you, and so this is a situation, again, similar situation, 12 months, stay out of trouble. I assume there was this at Walmart? Okay, you can't go back to Walmart as part of the agreement as well, but they've already trespassed you, so maintain law-abiding behavior. Hopefully this is a one-off and it doesn't happen again. And hopefully in 12 months, when this comes up for review, we see that everything's been paid, everything's been taken care of, no problems, and we can just summarily dismiss this and you guys are done with Yelm Municipal Court, okay? All right, I'm gonna sign this order. There'll be $250 costs plus the $200 defense reimbursement. You can make payments on that. And again, good luck to you. Hopefully this is a one-off. All right, take care of yourself. That's all for today. You can get a copy of both of you can get copies at the window. Okay.
Next matters are going to be Elias Pettit.
It's 10 o'clock.
10 o'clock, yes, sir.
You are Elias David Pettit?
Yes, sir.
Good morning. Cause number, let me get to it just a second. Cause number 380220357. 380354741, 480639497. What are we doing with Mr. Pettit's cases today?
We are. So on case number ending in 357, we're going to be dismissing count 1 in exchange for a plea to count 2, the interlock violation. On the next case ending in 741, we're going to be entering a straight plea to count 1, the theft, and then the city's going to move to dismiss count 2 in that case, dismiss the criminal trespass. And then in the last case, ending in 497, the city's going to dismiss counts 1 and 2, the controlled substance violations, in exchange for him entering a plea to the use of drug paraphernalia.
All right. All right, Mr. Pettit, looks like this statement of defendant plea of guilty is a plea to use of drug paraphernalia under 4A0639497. Plea to theft third under 3A0354741. Plea to an operated motor vehicle without ignition interlock under 3A0220357. Does that sound right, Mr. Iverco? And the remaining charges would be dismissed. Is that your understanding? All right, Mr. Pettit, you have a chance to read through this document with Mr. Haverco?
Yeah.
Did you have enough time for him to answer any questions that you have? Okay. And you understand paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty?
Yeah.
And at paragraph 6, the use of drug paraphernalia is a misdemeanor, means the maximum penalty is 90 days in jail with a $1,000 fine. Theft third is a gross misdemeanor. Maximum penalty, 364 days in jail with a $5,000 fine. Operating motor vehicle without ignition interlock is a gross misdemeanor as well. Maximum penalty, 364 days in jail, $5,000 fine. You understand there's a recommendation in this document. I don't have to follow. I can sentence you up to the maximum?
Yes.
Okay. Mr. Iverco, did you discuss any potential immigration concerns?
We did, Your Honor.
Okay. All right, Mr. Pettit, paragraph 11 states the following occurred in the city of Yelm. On April 1st, 2023, I drove a motor vehicle without ignition interlock device as ordered by the Washington State Department of Licensing. On April 16th, I stole merchandise from Walmart. Of April 16th of 2023, I stole merchandise from Walmart. On October 19th, 2024, I possessed a container that I was using to store heroin and unlawful controlled substance. Are those your statements?
Yes, sir.
As to the charge of operating motor vehicle without ignition interlock, how do you plead, guilty or not guilty?
Guilty.
As to the charge of theft third degree, how do you plead guilty or not guilty?
Guilty.
And as to the charge of use of drug paraphernalia, how do you plead guilty or not guilty?
Guilty.
Yeah, I'll find your pleas are made knowing voluntarily to each of those counts. Based on the pleas, I will dismiss the driving with license suspended under 380220357. Dismiss one count of criminal trespass under 380354741. Dismiss a controlled substance knowing possession under cause number 480639497. And one count of controlled substance knowing possession under 480639497. I'm gonna turn to the city for discussions related to sentencing.
Nothing from the city.
Mr. Averco?
Yeah, are there any costs associated with this that you have to pay anything? Are you working right now?
I just got a job.
What do you do?
Concrete coating.
Okay.
Yeah.
Because okay, they're asking for a $300 fine in total.
Yeah.
I was just asking him some questions about his job situation. Apparently just got a job. It's involving working with concrete, so he may be able to pay the fine, but just wanted the court to know, he brought with him some paperwork from Pierce County Alliance. He's been involved successfully with some drug treatment. And it looks like he's doing well. I was just asking him whether or not he had costs associated with that, whether or not to make an argument to waive costs, but apparently there are no costs to him for that, and apparently he has just gotten a job, and so the city was willing to make a lesser recommendation on the fine for all three cases, so.
Okay. All right, Mr. Pettit, anything you'd like to say before sentencing?
No, not really, sir.
Okay, it looks like 23, probably 24, you were in the depths of addiction, fair to say? Yeah, I mean, it's, yeah, but you're doing pretty good now?
Very
Good, good. Okay. All right, I'm gonna follow the recommendation. Gonna impose 90 days, suspend all 90 days under for drug paraphernalia, $1,000 fine, suspend all $1,000 for a period of 12 months. Those 364 days in jail, suspend all 364 and theft third, $5,000 fine, suspend all $5,000 for 12 months. And impose 364 days in jail, suspend all 364, same $5,000, suspend all 5,000 for a period of 12 months on the operative motor vehicle ignition interlock. Following conditions, gonna have you pay just $300 probation fee on that over the course of a year, so you can make payments on that. Law-abiding behavior, make all court hearings, and just, I mean, you know what you need to do.
Yeah.
I don't need to tell you. So, okay, you're gonna get a copy of this and you look great, and it's glad to hear you're moving out of that. So, all right, I'll sign this. You can grab a copy at the window.
Appreciate it.
Yep, take care of yourself.
What's the highest grade you ever went to?
Got it, signed it.
Yeah, so you graduated?
Yeah.
Okay.
Okay. All right, who have we got here, Mr. Havercourt?
This is Mr. Raddick. It looks like Raddicky, but it's supposed to be Raddick.
10 o'clock?
He's on the 11th, I believe.
That's right. It's the Y is added. It's not supposed to be there, right? Mr. Raddick? That's right. I remember this case. All right. This is cause number, your Bo Raddick, cause number 2A0604488 and 2A0604489. Mr. Raddick is present out of custody with Mr. Haverco. What are we doing with Mr. Raddick's case?
We are on the first case ending in 488. Counts 1 and 2, city is going to amend to an infraction. And then the city is actually going to dismiss count 3, and then he's going to enter a guilty plea to the single count of false statement to a public servant on the case ending in 489.
Okay. Give me 1 second to get to that. All right, Mr. Raddick, cause number 2A060448. It's a charge, currently charged as driving with suspended license, second degree. City's moving to amend this to an infraction, which is no valid operating license with ID, with a usual penalty of $150. Is that correct?
That's correct.
Okay. Are you licensed? Are you on your way to getting your license? You're relicensed. Okay, great. That's fantastic. And then on the failure to transfer title, we're gonna, the city's gonna amend that to an expired registration less than 2 months. Same penalty amount?
That's correct.
Okay. And then with that, the city is going to dismiss the no ignition, the ignition interlock, and then we're gonna have a plea to the false statement to public servants. Does that sound about right? Okay. Did you have enough time to read through this statement of defendant on plea of guilty with Mr. Haverco? Yes. And did he answer all the questions that you have? And Mr. Haverco, any immigration related issues?
No, Your Honor.
Or did you discuss those with him?
We did.
And Mr. Raddick, paragraph 5 talks about your constitutional rights that you're giving up. You understand those rights and you understand you're giving them up by pleading guilty?
Yes, I do.
And there are, on this, the one remaining criminal matter is a gross misdemeanor, means the maximum penalty is 364 days in jail, $5,000 fine. You understand there's a recommendation here I don't have to follow. I can sentence you up to the maximum. Okay. So paragraph 11 states, on December 1st, 2022, while in the city of Yelm, I identified myself to the Yelm police officer with a false name in order to conceal my true identity. Is that your statement? So as to the charge of providing false information to a police officer, how do you plead guilty or not guilty? Okay, I'll find your plea is made knowingly and voluntarily. No one's made promises. And you got a warrant out of Cowlitz?
Yeah, I'm on the docket tomorrow to.
Good. What's making you get all this stuff taken care of? What's driving you to get all these things taken care of?
A lot of things, family, son.
Good.
Just wanting a better life.
Yeah. Good. Yeah, you're doing great. My bet is there were some substance use issues. Yeah, back in the day. No, I can tell. So that's awesome. I mean, it's fantastic. I'm obviously going to follow the recommendation. Let me sign this really quickly. It's just it's nice to see people come in. Like, you're doing great. There was a couple other folks today that have been clearly different than where they were a couple of years ago. And it's nice to see when sometimes I don't get many of those in a day. So I'll follow the recommendation. $150 on the individual with ID, $150 on the expired tabs. Dismiss the other counts that we talked about.
Would the court be willing to not impose a probation fee on the criminal matter since it's $150 each on the infractions?
Yeah, what we'll do on that one is I'd like to impose, why don't we go 200 total on the infractions? I'd like to leave the probationary fee because that goes to the court to reimburse the court costs. So instead of 300, I'll knock it down another $100. So $100 on each infraction. Okay. But I do want to leave the 250. You can make payments on that because that's a payment. The infraction payments, 90% of it goes to the state. The 250 stays in this court to pay for Mr. Haverco, to pay for the staff, to pay for their services. So that goes back to the city of Yelm, which is, I think, important. You can make payments on that. Appear timely at all court hearings, no criminal law violations. Looks like I covered everything, folks. All right, Mr. Raddick, great job. Good luck to you. All those things. Keep at it. All right, you'll get a copy at the window, okay?
Thank you.
Do we need to take a break for a few minutes?
Let's see if
Okay.
there's someone here that I still have that might be ready, so. Kissful? Let's see here. Give me a second. Yeah, let's go ahead and take the matter of David Kistel on the 10 o'clock. Come on up.
Good morning. Morning, David Ivan Kistel. Files number 680010628. Mr. Kistel's present out of custody with Mr. Haverko. What are we doing with Mr. Kistel's case?
We're going to submit a motion for a continuance.
Okay.
Waiver. We'll have him sign it, you know. Go ahead and
This is
sign.
the paper that I settles takes here
Okay,
that they sent me back.
okay, go ahead and sign here. He has signed the motion and waiver.
Okay. Pull that up. All right, Mr. Kistel, I have a statement or a motion to continue this matter. What date? How much time do you want on this one?
How long do you want to set it out to accomplish what
we
you?
could do 3 months, that'd be.
If
great,
we, yeah, we
because
did a
it's
long
gonna-
waiver on
it's
purpose, so
a
if the
little
court's
bit
willing to maybe go out 90 days.
Yeah, I don't want you to come back in here a bunch of times if we're not going to be ready, so long as you're not getting new law violations. We'll be as patient as humanly possible, so long as you're not recommitting crimes.
Said I've been.
Yeah.
To the Department of Licensing, and I've got a response from them.
Good.
Uh,
So let's put it into October.
it's like,
So we're going to reset this to October 8th at 10 a.m.
Sure.
Okay, and commencement date of October 31st, so that'll allow us more time. Gate license, that'd be fantastic if you can do it.
I've been trying to contact them in every way possible.
Yeah,
Faxing, emailing.
keep at it. It just takes time.
Yeah.
All right, October 8th, 10 a.m. All prior conditions remain in effect. Stay in touch with Mr. Haverko. Give him an update every couple months, maybe. And then we'll plan on seeing you back here on October 8th, hopefully with a license. All right. Okay, I'll sign this order.
Is there anybody you know in the Department of Licensing that I could potentially contact regarding this?
You know, there's not. I used to have a phone number that was kind of a backdoor phone number years ago when I was early in my practice that I could call and actually they'd answer on like the second ring. That number was cut off. And everybody they just have to go through the channels. I have to go through the channels.
Yeah,
So,
I've been going through every avenue possible.
yeah. Keep at it. All right. Good luck to you. Grab a copy of the order at the window.
From the window, right?
The window. Yep. Yes, sir.
Good luck. Yeah.
We can take the matter on the 10 o'clock, the matter of Elias Joshua Gonzalez. It's item number 4. My notes reflect he is now suspended in the driving in the 3rd degree and the city might have a motion.
All right, you are Elias Joshua Gonzalez? All right, good morning. This is cause number 680024309. Mr. Gonzalez, so what the city does in these cases, generally speaking, is the city will take a driving with suspended license in the 3rd degree and will automatically amend that to a infraction, which is a no valid operating license with ID, and impose $150 fine. Reason I say the city generally does that is because looking at your record, I don't know, how old are you, Mr. Gonzalez?
Oh, 20.
Okay, you're pretty young. Your record's not terrible. Do you know what you need to do to get what do you have to do to get your license back?
Take the driver test. Fine. Yeah,
Okay.
So get it restated.
Okay. It makes your life a lot easier, a lot cheaper if you get that done. Okay. Plus you're not looking over your shoulder. You're not doing all those things when you're driving. So, I'll go ahead and sign this order. Going to impose $150 cost. You'll have to pay that. You can pay that at the window, make payments if you need to get your license back, because what the city's transitioning into a bit of a, different mode sort of operation where when we're getting people in that we've given this deal to a bunch of times, we're not giving them the deal. And if they've got enough of them, they get held in jail. In fact, there was a couple of people here earlier that sat in jail for like 5 days because of these driving with suspended licenses. And it's not that it's not the crime itself, it's the intentional, deliberate sticking the middle finger up at the rules, you know? And you don't seem like that kind of guy. We're working on getting your license. You get your license back. It's just easier for everybody, okay? All right, man. Grab a copy at the window. I'll sign the order. Good luck to you. Yep.
So, now would be good time to take a break because This is gonna be,
Who do we have?
Michelle Lyle.
It's on the 9:45.
It's on the 8:30, she bailed.
Oh, okay. Good morning, Ms. Lyle. It's cause number 580448978 T00497906. Ms. Lyle's present out of custody. What are we doing with Ms. Lyle's case
We're
today?
gonna be asking just to reset.
Okay.
Or. Go ahead and sign here. And you can sign waiting through 128.
Okay. All right, Ms. Lyle, so here's a look at something. How much bail was bail posted on this?
Yes.
A bond? How? Okay.
Would the court consider amending the conditions of release to a PR?
And you said cash bail was posted?
Yes, we just.
So Ms. Lyle, that's what I'm kind of thinking about here. The issue in your case, the reason bail was posted is because, you've got cases pending and you're getting new law violations. Okay? And the goal is to get you to stop allegedly committing law violations. I don't think it's a concern that you're not going to show up for court, but until you get your license taken care of and whatever that is, and the conditions are pretty clear, not to operate a motor vehicle without whatever those requirements DOL are. What are the city's thoughts? Okay. So Ms. Lyle, I'm going to release your bail. You'll be released on your own recognizance. I just want to make a point that you understand kind of what's going to happen if we catch you driving again or commit any law violations. Okay. So unfortunately, the money's going to take it usually takes a couple weeks to get sort of filtered through. It'll get sent back to whomever posted. So, okay. Based on that, Mr. Haverco, I will, modify the release conditions to a PR release. That'll return the bond.
Thank you, Your Honor.
And,
Right there on your phone number.
I'll fill out whatever I need to fill out to do that. Okay.
Gives one.
Whatever, well, the bail's here, right? It's you guys, if you guys are comfortable acting on what's there, then I'm fine with it. I don't need a separate order for that. Yep.
Well, there'll be a court notice for you when you go to the clerk's window. She'll have something for you.
Okay, I can go.
Well, just wait.
Oh,
I'm sorry.
okay. 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 Wait.
All right, next court date, Ms. Lyle, is going to be September 10th, 2026 at 11 a.m. Stay in touch with Mr. Haverco. If there's anything you can get done working with this system, that would be fantastic. All prior conditions remain in effect. I am also indicating on this form that cash bail is to be released. Okay? All righty, you'll get a copy of this at the window. And again, stay in touch with Mr. Haverco. Good luck to you.
Moving on to the 10 o'clock calendar, item number 3, Salvador Fernandez.
All right, good afternoon. Good morning, Mr. Fernandez. This is cause number T00587351. Mr. Fernandez is present, out of custody. What are we doing with Mr. Fernandez?
He is signing a stipulated order of continuance, the matter to be set over on the usual conditions, no new criminal law violations, $250 court fee.
Okay, Mr. Fernandez, I don't spend a ton of time going over these because these are this stipulated order of continuance that you're entering into is a contract between you and the city. All right, really, I as the court don't play much of a role in this. Do you feel like you've gone over this agreement with your attorney? Do you feel like he answered all your questions that you have about it? You understand the rights you're giving up? And do you understand what happens if you violate the conditions?
Yes.
Okay. And if you're successful, at the end of 12 months, this matter would be dismissed. Sound right? Okay. All right, Mr. Averco, anything I missed on this? Okay, you're gonna pay $250 in costs. You're gonna appear timely at all court hearings. You're gonna have no criminal law violations. Is there still a active no contact order in place? Okay,
The trial's in a week.
okay. I think I would like the parties to, I think this should be added to this. He needs to abide by all all prohibitive no contact orders. Okay. Okay. If that gets lifted, then there's not an effect. If it stays in effect, then it stays in effect. Okay. All right. Any questions about that? Talk to Mr. Haverco. I'll sign this order. Mr. Fernandez, good luck to you. Okay. You get a copy at the window.
Next matter is going to be Tanner Kinney.
Good morning, Mr. Kinney. This is cause number T00494174 and T00497008. Mr. Tanner Kinney is present. What are we doing with Mr. Kinney's case today?
There's a couple of cases here and on the case ending on 174, he's going to plead guilty to count 1, dismiss counts 2 through 5, I guess. And then on the case ending in 008, he's going to enter a plea to the single count of malicious mischief.
Okay. Hey, Madam Clerk, I'm not, once I sign it, can I sign, so after I've signed it, can I edit it? Okay, on the Lovett case, we need to put that he's released. So Sonia's gonna have to do a new order. Okay, thanks. Okay, yep. All right, let me get to Mr. Lovett's case. Mr. Kinney's case, sorry. All right, Mr. Kinney, I have before me a statement of defendant on plea of guilty, indicating a plea to malicious mischief, 3rd degree under cause number ending 008, plea to a violation of no contact order under cause number ending 174, dismissal of 1, 2, 3, 4 other violations of no contact order under cause number ending 174. Does that sound right? All right. Mr. Kinney, these are gross misdemeanors, which means each of these charges carries a maximum penalty of 364 days in jail with a $5,000 fine. You understand there's a recommendation in here I don't have to follow. I could sentence you up to the maximum. And paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand those rights? All right, Mr. Haverco, have you discussed any potential immigration concerns?
We have.
All right. These charges, the plea to this will also result in your inability to possess, own, or maintain a firearm. Do you understand that? Okay. So we'll need a separate order on that. All right. So Mr. Kinney, paragraph 11, this document says the following occurred in the city of Yelm on June 17th, 2026, during an argument. I caused damage to Rachel Mortland's vehicle. My ex-girlfriend later on June 20th, 2026, I had verbal contact with Rachel Mortland, which I knew was in violation of domestic violence no contact order. Are those your statements? So as to the charge of malicious mischief, third degree, how do you plead guilty or not guilty? Okay. As to charge of violation of harassment, no contact order, how do you plead guilty or not guilty?
Guilty.
Okay. Find your plea is made knowingly and voluntarily to each of those charges. No one's made any promises or any other promises to get you to plead to make those pleas. Are we gonna do sentencing today?
Yeah, we are.
Okay, I'll hear from the city first. Mr. Iverco?
Nothing to add. I can just tell you he is sorry, I think, for what he's done, and he feels like he just got himself into over emotional in a relationship that was, kind of not going well, and reacted poorly, and he's commented on how he's not happy with his actions.
Okay. And Mr. Kinney, you don't have to say anything. Is there anything you'd like to say before sentencing? All right. I do have a question for the city. Has the city had any contact with Ms. Mortland? Is Ms. Mortland present? Is there anybody on Zoom? What are the city's thoughts on not having any contact with Ms. Mortland on this thing? I mean, we've got 4 or 5 allegations of violation of a no contact order. I'm sorry, say it again.
So the city or the independent needs to be restrained from the other.
The only reason why I want to contact her again is because we have a daughter together. So, and I haven't seen her in a month.
Is there any way any allowance can be made for some type of?
So does the violation here, does it stem from the malicious mischief from our no contact order? Well, without any additional information, I'm not willing to modify the no contact order at this point. Is there any recommendation for anger management or domestic violence treatment or evaluation? Is there anything? No. What's the current no contact order say?
Physical exchanges shall be carried out by a third party.
Okay, and I think if I remember correctly, she had requested that initially. Okay. So I guess the issue at this point is this: without any additional information, without the victim here, I'm not in a position to make any changes. If the victim wants to bring a motion, I can certainly entertain that motion at that time. Obviously, Mr. Kinney, I'm hoping this is the end of all this nonsense. But we're a month and a half out, and I'm not willing to modify the no contact order at this time, but I'm not saying I wouldn't do it in the future, but it's going to require maybe Mr. Haverco can reach out to the alleged victim, or to the victim in this case, and have that discussion. Okay. So I'm going to follow the recommendation. I'm going to impose 364 days in jail. I'm going to suspend all 364 on the malicious mischief, going to impose $5,000 fine, suspend $5,000 for a period of 12 months. On the harassment or violation, going to impose 364 days in jail, suspend 364, $5,000 fine, suspend $5,000 for a period of 12 months. The other counts of violation protection order will be dismissed without prejudice. Additional conditions are gonna be law-abiding behavior. You're gonna pay $250 monitoring fee. Restitution is reserved and to be left open for 365 days. Am I allowed? I guess if the parties agree, I can leave it open for that long. But I would like maybe the prosecutor's office could reach out to the alleged victim and ask her about restitution as well as the no contact order. Please. No criminal law violations, make all your court hearings, abide by all protected prohibitive court orders. We still have the court order out of this court until otherwise lifted. And Mr. Kenny, I am gonna add one thing to this. I'm gonna have you complete a domestic violence victims panel. Can be online, it can be in person. I just think it's something that might help you. So I'm gonna have you do that, within 90 days. And then just make sure proof that gets to the court. Okay, and also that'll help in my analysis or anyone's analysis as it relates to the no contact order issue as well. Okay, all right. And I think those are offered, Mr. Averill probably, those are offered by Lewis County and places like that. So, okay. All right. Anything else from the city? No. Mr. Averill, you think I missed anything?
Nothing else, Madam Clerk, does he need to sign all of those documents? Needs and the firearms orders.
So, yeah, the firearms orders.
I've signed that order.
It's the art firearms and declaration on site, which you can sign now.
I signed you.
Needs to have all those other documents to be.
And then the no contact order, do we need to do a new one? Okay. Yep.
We don't believe we need to do the surrender because there's nothing to surrender.
Just declaration of non-surrender.
Will be the. Oh, definitely. No. Sign again. Please sign the declaration. Sure. Get that out for him. You mean the class?
Oh, just talk to the clerk. Oh, yeah, sure. Yeah, sure.
I'll give her a call. See what she feels about modifying something with the order, because
Basically what you'll need to do, I know you don't have a big file. But if you did, you'd basically go to court. So you got a bearing.
There's already a parenting plan.
Oh, there is?
Yeah,
What is it?
already got set up.
Oh,
Do we need a civil standby?
were you guys living together? You have any of your stuff there? No, he was not living there. He doesn't have any stuff
Okay.
there.
Nope.
But, I guess we just tell the court, I didn't realize this, but I guess there is a pairing plan.
Yeah, we already had gotten a parenting plan.
I don't know if that would affect.
I mean, at this point, I think if Miss Mortland wants to come in and after the prosecutor talks to her, then she can, it's a pretty simple process to get if she wants to file a motion.
Yes, if she doesn't want to have contact, but at the same time, he wants to try to exercise his rights. I've seen sometimes, there'll be an order saying only contact limited for the sole reason of you know, complying with the parenting plan or something of that nature.
This allows contact for purposes of exchanging the kid, which I think will encompass the parenting plan. And then if she doesn't want him, then that's a parenting plan issue. Okay. Yep, perfect. And I'll sign that. Oops. I think you're still in it. Got it. Okay. All right, I've signed that order. I think everything that I've signed, need to sign is there. Is that all, I think?
Yeah, that should be it.
Okay. I think that's it. All right, Mr. Kinney, good luck to you. You can grab a copy of the orders at the window and I think the prosecutor's office will be in touch with Ms. Mortland, so we'll see where we go from here. All right, good luck to you. Yep.
Next matter would be Jamie Stevens.
Jamie Stevens?
Jamie Stevens.
This is cause number 6A00896675.
So we, she would like to continue this matter, and I'm gonna ask her to sign the motion here.
We have Speedy's good through December of 2026.
Yeah, and I debate on whether to file another one.
Okay.
So go ahead and sign here. Just pushing speedy trial out to give us time to reset. So this kind of pushes out about another month.
Okay.
So she just needs some time to kind of think things over, and we need a little more time to discuss so we can trash the SOC for now.
Okay.
I just want, I don't.
Sure.
I had affirmed to do a head split, like affect the misconduct to them. Gonna look into, so I'm just gonna get a defense attorney and ask that question. Because it could, if I take the deferment, then it can mess with the misconduct or whatever.
Well, it's not a conviction.
But essentially, I mean, it can, if I,
You want a late September date or October date?
well, that's why I was asking you.
This case is getting a little stale. It's from January.
Yeah. September.
Okay.
Oh, I mean, I don't want it to be on my record, but also, but if it indicates that if I do the,
Next court date is going to be September 24th at 10 a.m. Ms. Stevens, you'll get a copy of this. There's also a waiver speedy trial with a commencement date of October 30th, which will extend speedy trial through January 28th of 2027.
okay.
Okay, I've signed that order.
Okay.
Yeah, the date will be in your paperwork.
Okay.
Yep, yep.
All right.
And next matter will be Brandon Turner.
All right, good afternoon, Mr. Turner. This is cause number 6A00023336. Mr. Turner's present out of custody. What are we doing with Mr. Turner's case today?
An SOC, sign. Yeah, usual conditions, matter to be continued for 12 months, condition no new law violations, criminal law violations, $250 court fee.
Okay, Mr. Turner, you have enough time to go over this with Mr. Haverco, this contract? And do you understand what it entails? Okay. One thing here. All right, this is an opportunity to keep a theft off your record, okay, which is going to help you in the long run. So I'll go ahead and sign this order. Conditions are stay away from Walmart. You're trespassed from Walmart anyways. Pay $250, appear at all court hearings, have no criminal law violations. You understand those conditions? 12 months from now, if you do all those things, if all those things are taken care of, this matter will come up for review. And if you're in compliance, it'll be automatically dismissed. Okay? All right. Good luck to you. And you can grab a copy at the window.
Hey, free to go. Next matter, moving on to the 11 o'clock calendar would be Bruce Bell. Bruce just sent.
All right. City of Yelm versus Bruce Bell, cause number 200511309. Mr. Bell is present out of custody. What are we doing with Mr. Bell's case
He's
today?
going to enter a straight plea to the count 2, use of drug paraphernalia. Upon the court's acceptance of the plea, city will move to dismiss count 1.
All right. And you are Bruce Bell? All right, Mr. Bell. Have before me a statement of defendant on plea of guilty that is anticipating a plea of guilty to a use of drug paraphernalia charge. In exchange, once that is accepted, the city move to dismiss the controlled substance knowing possession charge. Does that sound about right? Okay. Did you have enough time to read through this with Mr. Haverco? And did he answer all your questions? He did not answer all your questions. He did? Okay. Did you read it or did he read it to you? Both? Okay. And I'm going to touch on just a couple high points of this. Number one, paragraph 5 contains a number of constitutional rights that you're giving up by pleading guilty. Do you understand those rights? Okay. And this is a misdemeanor, which means the maximum penalty is 90 days in jail, the $1,000 fine. You understand there's an agreement. There can be a recommendation contained in this document. I don't necessarily have to follow that recommendation. I can sentence you up to the maximum. Okay.
Shame about Tom.
Oh, yeah. Yeah. Thank you. Tom was a good, Judge Meyer was a good guy. Mr. Haverco, have you discussed any potential immigration concerns?
We have your honor.
Okay. All right, Mr. Bell, paragraph 11 states, on June 15th, 2026 in the city of Yelm, I possessed paraphernalia, tubing and a pipe I had used to consume methamphetamine, which is a controlled substance. Is that your statement? So as to the charge of unlawful possession of drug paraphernalia, how do you plead, guilty or not guilty?
Guilty.
Okay, I'll find your pleas made knowingly and voluntarily. No one made a threat or promises of any kind of entered plea. And I'll hear from the city. Anything additional?
No.
Okay, Mr. Haverco?
And nothing else.
All right. Mr. Bell, anything you'd like to say before sentencing? You don't have to say anything. If you choose not to, it's your call. Okay. All right, I'm going to follow the recommendation. Find it. All right, I'm going to dismiss one charge of controlled substance knowing possession under cause number T005113009. Going to enter a finding of guilty to the charge of use of drug paraphernalia under the same cause number. Going to impose 90 days in jail, suspend all 90 days, impose $1,000 fine, suspend $1,000 for a period of 12 months. Going to impose a $250 monitoring fee for the next 12 months. Conditions are going to be your appear at all court hearings, no criminal law violations, and basically stay out of trouble.
Is there any chance I could get a reduction on the fine?
Are you working right now?
Yeah, I work 3 days a week.
Okay. For these kind of charges, I'm typically not inclined to do it. You can make payments on it. So short answer, I'm gonna leave it at 250. If something changes, over the next year or whatever, let me know. Let Mr. Haverco know, but at this point, I'm gonna leave the 250 in place. And then you can make payments, set up payments through the court.
Yeah.
Okay. All right, I'll sign this order. And then you can grab it, if you want to make the payment and grab a copy at the window, we'll go from there.
Okay,
All right, good luck, Mr. Bell.
thank you, sir.
Yep.
Next matter will be Jordan Boyd.
All right, this is cause number 6A0002345. Mr. Boyd is present out of custody. On the 11 o'clock calendar, what are we doing with Mr. Boyd's case today?
We need a motion for a continuance speedy trial expiration through 1/29/27. Still needs to get an evaluation. We also wanted to ask the court today about whether or not the court would be open to removing, right, the scram.
Yeah.
Yeah. Yes, so the
Removing
scram-
what?
Removing the scram device, if that's something the court might entertain. It's pretty expensive and
So Mr. Boyd, the short answer is gonna be no, because if, in order to do that, if you had got, I mean, have we got no evaluation yet or anything like that?
No.
Okay, what I normally would require is an evaluation, and maybe if, and I'm looking at your record, if they don't recommend treatment, I'd be very surprised. But at this point, with your record, the pending DUI out of Thurston County, Thurston County probably has a scram device on you too. Yeah, well, I'm gonna leave it on for now. I'd like to see an evaluation. I understand it's expensive, but I'd like to see those efforts taken before I remove it. I'm not gonna say I won't consider it at the next one, but I'd like to see the treatment evaluation, and if there's any treatment recommended, I'd like to see in treatment.
Okay.
And that'll help you in both the cases that are pending. Okay, so I appreciate the request. I'm just not willing to do it right now. Okay, all right. So we're gonna continue this to, what's the date? What's the request date?
okay.
I wouldn't want to go out to October. Let's go September 24th. Okay. September 24th. Well, that's 2 months. We could go sooner if you're going to get the evaluation done, and we could address it sooner if we think it's going to cause some, if we think it's going to.
Yeah. Yeah, it is. Yeah, he doesn't have one scheduled yet.
Let's leave it for the 24th of September. If for some reason there's some advantage to getting it done sooner, you can contact Mr. Haverko and we can maybe squeeze you on sooner. We might be able to address the scram, and Mr. Haverko will walk you through that. Okay. September 24th at 11 a.m. All prior conditions remain in effect, including the scram. Stay in touch with Mr. Haverko, and we'll see you back here on the 24th. All right. And you can grab a copy at the window. Thanks for your patience today.
Next matter will be Nathaniel Collins. His current suspension status is 3rd degree. So I was thinking the city might have a motion.
All right, Mr. Collins, you were the beneficiary of the city's goodwill in what they do in these, in not all circumstances, but in many circumstances. When someone is suspended 3rd degree, the city has a standing motion to amend the charge to an infraction, which in this case is no valid operating license with ID, and they impose a $250 fine. Now I'm gonna let the city know, Mr. Collins got this benefit, this identical benefit, it looks like, back in June 30th of this year. Okay, Mr. Collins, I don't know what you need. Do you know what you need to do to get your license back?
Yeah, so there was that month there, where I was kind of lacking there with income.
Okay,
I finally just get my income up, I've had a first $1,200 a month here.
okay.
And I don't know if you guys can see on your side, but I started paying back what I needed so I can actually go get it reinstated. It's just gonna cost to get the reinstating fee and then paying you guys.
Safe, well, as long as you're making payments here and nothing gets sent out to DOL, you have to do a safe driving course and your reissue fee. Okay, all right, well, you're getting the benefit of the deal, $150, you can make payments on that. And get your license back, save you money in the long run. Okay,
It's a difficult thing, right?
yeah, I get it, I get it, I get it. So go out there to the window, grab a copy of it, and hopefully we'll see you again with a license. All right.
Next matter is gonna be Molly Kirby.
Okay. Please sign this order. All right. On the 11 o'clock, 10 o'clock,
She's on the 11 o'clock. Last name Kirby with a K.
Molly Rayanne. All right, you are Molly Rayanne Kirby. Cause number 5A0628216. Miss Kirby's present, out of custody. What are we doing with Miss Kirby's case?
She's going in or a straight plea to the charge. Your Honor.
All right, Miss Kirby, you can get to that screen. All right, I have a guilty plea to a charge of theft third degree, Miss Kirby. Do you have a chance to review this with Mr. Haverco? Did he read it to you? Did you read it to yourself or both?
Well,
Okay, feel like you get enough time with Mr. Haverco to have him answer all your questions? Okay. And paragraph 5 of this document contains a number of constitutional rights. You understand you're giving up those rights by pleading guilty? And Mr. Haverco, have you discussed any potential immigration concerns?
Yeah.
All right. So Ms. Kirby, the other thing is this is a maximum penalty. This is a gross misdemeanor, maximum penalty, 364 days in jail, $5,000 fine. You understand there's a recommendation I don't have to follow. I could sentence you up to the maximum. Okay. Paragraph 11 states on July 8th, 2025, in the city of Yelm, I stole merchandise from Walmart. Is that your statement? That's the charge of theft third degree. How do you plead, guilty or not guilty? Okay, I'll find your plea is made knowingly and voluntarily. No one's made threats or promises of any kind to get you to enter the plea. Anything additional from the city? Anything additional, Mr. Haverco?
No, Your Honor.
Ms. Kirby, you don't have to say anything, but is there anything you'd like the court to consider before sentencing? Okay.
She would like to, I think, the city asked for its usual $250
oh,
court probation fee. She did mention to me she's not working at the moment. She's looking for work. So I don't know if the court would be willing to either waive or reduce the fee.
So
I did have I had a job interview a couple days ago. I'm still waiting to hear back, but, my other case that I had going on, I'm in, Pierce County Drug Court. I don't know if you know, if you're familiar with that or not.
I am.
So that's what I'm doing now. So I actively participating in that. This was the last thing I had to, wrap up with, my last legal thing that I had to take care of other than that.
How's drug court going? Okay.
The classes 4 times a week and either 2 AA or 1 AA or 2 pro socials is what they call it with my groups.
Okay.
Super jam
Well-
busy.
When did you start drug court?
It's been a couple weeks.
Okay.
I opt in officially, I think on the 13th.
Okay.
Yeah, it's been a few weeks.
What I'm willing to do, Miss Kirby, is this. I'm not gonna waive the $250 at this time. But what I'd like to do is if you want to put this on, or if you want to contact the court, I'd like to see 6 months from now. And if you're doing well, if you're in drug court and things are doing well, and there's not any new law violations, I will gladly waive the $250. Fair enough. And what you can do is you can contact the court. Will make a note on their notes here. You can contact the clerk. I get the requests all the time. You don't have to come to court. I can look at it and I can make a decision off the record. But I'm going to look at your record and see what's going on. And if you're doing what you need to do, I'd glad that's the best $250 the city ever spent. Okay. All right. I'll sign this order. I'm going to impose 364 days in jail, suspend 364, impose $5,000 fine, suspend $5,000 period of 12 months. $250 probation fee remains in effect, but we can review that in 6 months if you reach out to us and everything's good. Appear timely at all court hearings, no criminal law violations. You're not to go to the property of Walmart. They're trespassed you anyways. And good luck in drug court. Okay, I'll sign this order. At least I think I'll sign the order. Yep. Okay, who have we got here?
Kendall Larson.
Kendall Joyce Larson?
Yes.
All right.
1 second. Parties aren't ready to resolve the matter yet. We're still discussing the matter. So-
Okay, all right. You are Kendall Larson? All right, Ms. Larson, cause number T 005085001. I see that Mr. Haverco's court-appointed counsel, with your contributing $200 of that cost. What are we doing today, Mr. Haverco?
This gets to reset in the ordinary course. The parties need to have some additional discussions.
Any objection from the city?
No, it's great.
Okay. All right, Ms. Larson, I'm gonna reset this matter. I've got a waiver, a new date set, waiver for commencement dates to start October 29th, 2027? Commencement date?
No,
Madam Clerk, could you, I assume in October 29th, 2026? Okay. Clerk's gonna fix that. Okay, commencement date of October 29th, 2026, which means speedy trial would expire on January 27th, 2027. Does that sound right, Mr. Haverco? Okay, we're gonna reset this matter to,
and where's the young girl living? She's somewhere else.
She's living with her mom right now.
Does she want to come back?
I mean, school's about to start, so I don't know. They're in talks, so I don't know the full details. I just know that.
I don't know what the city's position is or the court's position is on the no contact order. This is malicious assault against what would be her stepdaughter, but it's not legally because she's not married to the father, but it's the dynamic is that of a stepmother, stepdaughter. The stepdaughter, I guess, is gonna be starting school soon and she's living out of the home.
Right now.
And so, but does she want to return home? or-
I believe so. I just try to stay out of that right now. I think that she wants to come back.
what I would say is this, is I would, maybe this city can reach out to the alleged victim if the victim brings this forward. I can't do it without the victim's input at this point, but we can certainly deal with that before school starts, but we would need to have something from somebody. Make sense?
Yeah.
Okay. So we're gonna set this for what date? You wanna do the 10th?
I mean, I'm about to have a baby, so I'm like, can we, end of September maybe or something?
24th?
Yeah, that should be fine.
Okay, let's do September 24th.
Yeah, that should be fine.
Okay. And if it's not, just get in touch with Mr. Hardy. So it'll be September 24th at 11 a.m. You'll get a copy at the window
Okay,
and we'll see you back there. Good luck.
okay, thank you.
Oh, great.
Christine Upton,
Right, okay. Yeah, great.
All right, good afternoon. Are you Christine Tuxon?
Yes, sir, I am.
Hey, good afternoon. This is cause number XZ 0406160. Note that this is a case from May of 2020. Theft third criminal trespass. Ms. Tuxon is present out of custody via Zoom. I remember you're in Yakima or Spokane, maybe?
No, I'm in Cowlitz County,
Oh,
Longview.
gotcha. Okay. What are we doing with Ms. Tuxon's case?
Ms. Tuxon, can I ask you, what's the highest grade you ever went through in school?
I went through 8th grade, but I did get my GED and I am in college right now.
And I'm making note of that
Okay.
in the plea form.
Okay.
And let's see here.
So Ms. Tuxon, I have a statement of defendant on plea of guilty. Mr. Africo, have you had a chance to go over it with me?
I have, yeah, and I anticipate she's going to be entering a plea to count 1 theft. Upon the court's acceptance of the plea, city would move to dismiss count 2 criminal trespass.
Okay. So Ms. Tuxon, I have a plea form, statement of defendant on plea of guilty to a charge of theft 3rd degree in front of me. Have you had a chance to go over this with Mr. Haverco?
Yes, I did.
Did he read it to you? Did you read it yourself or both?
He read it to me.
Okay. And do you feel like you've had enough time for him to answer all your questions?
Yes, I do.
Okay. So I'm going to go over a couple high points of this document. Paragraph 5 contains a number of constitutional rights. You understand you're giving up those rights if you plead guilty?
I do.
And theft 3rd degree is a gross misdemeanor, which means the maximum penalty is 364 days in jail with a $5,000 fine. You understand there's a recommendation in this document I don't necessarily have to follow. I could sentence you up to the maximum.
Correct.
And Mr. Haverco, did you discuss any potential immigration issues?
We did.
Okay. All right. Ms. Huxton, paragraph 11 states on May 22nd, 2020 in the city of Yelm, I stole merchandise worth approximately $65 from Walmart. The merchandise was recovered by Walmart's asset protection staff. Is that your statement?
Correct.
And as to the charge of theft 3rd degree, how do you plead? Guilty or not guilty?
Guilty.
Yeah, I'll find your plea is made knowingly and voluntarily, known as made threats or promises of any kind to cause you to enter the plea. And I'll hear from the city as it relates to sentencing. Mr. Haverco?
Nothing to add.
All right, Ms. Tuxon, anything you'd like to say before sentencing?
No, Your Honor.
Okay, looks like you're doing well. Are you in a treatment facility or some sort of facility or what's going on?
I'm in drug court.
Good. How's that going?
Going very well.
Good. Okay. What I'm going to do is I'm going to follow the recommendation. I'm going to impose $364 fine, 364 days in jail, suspend all 364, $5,000 fine, suspend all $5,000 for a period of 12 months. It will dismiss the criminal trespass 1st degree charge. There will be a probation monitoring fee imposed of $250. You can make payments on that. Conditions appear timely at all court hearings, have no criminal law violations, and you're not to go onto the property of Walmart. Do you understand those conditions?
Yes, Your Honor.
Okay, you're going to get a copy of this order. If you, for some reason you don't, you can get a copy from the clerk here, but I'm sure we'll email it over to you. And sounds like you're doing well.
Thank you. I do have one other matter I would like to try and ask you.
Sure.
So I am trying to get my license and I do have a few other places that's holding it up, but I do know that your court is one of the places. I was just wondering, is there any way that we could pull that out of collections so that I can start making payments on it so that I can try and work towards getting my license?
Madam Clerk, I don't have any objection to that, if we can do it. Okay, then, yeah, we'll go ahead and pull whatever we have in collections, we'll pull it out. And as long as you're making payments, it'll clear it.
Okay.
Okay?
Thank you.
All right. Anything else, Ms. Tuxon?
No.
Okay. All right. Thanks, folks.
Thank you.
Take care.
Bye-bye.
Bye-bye. Okay,
Do you want to do no shows now or wait or?
let's do it real quickly.
Okay, sure. On Gerald Christopher, he's got items numbers 1 and 2, have had no contact with him because he doesn't have a phone.
10 a.m. docket.
Yeah, 10 a.m. docket.
Theft 3rd, criminal trespass. 500 each, please. I've got Bayard, Mira Bayard on the 945.
Didn't we already?
Oh. Okay.
That's right. Yeah. Well, she's still late because she's not here.
This is.
Well.
Okay, so those are all warrant quash. We'll leave the warrant in place. Miss Bayard.
And then on the 11
Timothy
o'clock.
Higgins.
Oh, that was on the 9:45.
945. Timothy Higgins warrant quash. Leave the warrant active. And then we don't, who's here? So then I've got the Leah Kaluni.
City had a motion on that. That's the lady that was in the wheelchair. She has a caregiver. Yeah, you were dismissing.
Okay. Then dismiss Clooney. Morgan, Wesley Morgan.
1 second. 1 second. So I was given a number, called the number, the man answered, he said wrong number, then hung up. So I've had no contact.
2,500 cash or bond. Cody Flugmacher.
Did have a number. I think it's a good number. Left a couple of messages to call me back, never got a call back.
City's thoughts, 500 on each.
Which one is this?
This is Flugmacher with a P on the 11 o'clock.
Yeah.
Yep, 500 each, please. And then Corey Tash,
And Mr.
third degree, 11 o'clock down.
I've called him a few times. He just hasn't returned my calls.
Probably busy.
Yeah. Well, I had made a note to myself, he has some outstanding felony charges. Had he showed, I was probably gonna move to reset, but,
Okay. Theft third degree, 1,500 cash or bond. 1,500 cash or bond, please. All righty. Off the All right, ladies and gentlemen, this is the afternoon calendar, the arraignment calendar for Yale Municipal Court. I'm gonna call certain cases out of order. First one I'm gonna call is City of Yelm versus Raymond Johnston. Mr. Johnson, why don't you come forward? Yeah, that's fine. So, Mr. Johnston, I looked at your record this morning. You are licensed. Okay, so what the city does in that situation is because you're charged with driving with suspended license, but you came to arraignment re-license, city's gonna dismiss the charges. Okay? You're good, just gonna go to the window and grab a copy of the order of dismissal that I'll sign here in just a second. You're good to go. Thank you for getting your license back. Okay. You can just go to the window to the left, okay? And that's Raymond Johnston. Nope, you can go. Just I'm gonna sign the order and it'll be shipped over there in just a second. Okay. And then the next matter I'm going to call is City of Yelm versus Austin White. Mr. White, come forward. All right, Mr. White, you are in the same predicament, I think. You're licensed.
Yes.
Yeah. What do you have to do to get your license?
I just had to do the safety course and get the SR22.
Good. Okay, thank you for doing that. So with that, I'm gonna do the same thing. Gonna sign an order of dismissal. You go to that window on the left and we'll give you a copy of it. Thank you. Take care of yourself. White, Austin White. And I believe, is there anyone else in here who thinks they were charged with driving with suspended license in the 3rd degree and they are licensed? What's your name? Okay, why don't you come forward, Mr. Sage? So, Mr. Sage, do you think you are in a position where you can get this thing done within the next 30 days? Okay. Okay. What I'm willing to do, Madam Clerk, can we just reset Mr. Sage's arraignment 1 month? Okay, we're gonna reset your arraignment. We're gonna give you notice. Come back next month. If you're licensed, we'll have that discussion. Okay? What do you have to do to get your out-of-state license lifted? Okay, all right. So we'll go out to that window. We'll give you a copy of the order with new court date. It'll be, what date will it be? August 27th at 1 p.m. See you then. Okay, now the next group of cases we're going to deal with are, do I need to sign that on the Sage case? Okay. Okay. So next series of cases I'm going to deal with are people that are charged with driving with suspended license, just driving with suspended license 3rd degrees. Again, the city has a standing order on those cases. If you don't come in licensed, they will amend those charges under some circumstances. But in some circumstances, they will not. So I'm just going to go call through the record, starting with City of Yelm versus Andrea Cheroff. No response. Cheroff? CH? Okay. Come back to that one. Next matter is City of Yelm versus Christopher Harlan. Let me look at something on that. This is cause number 680225514. Mr. Harlan is charged with driving suspended license 3rd. Based on the city's standing motion, we'll make a motion to amend that to a no valid operating license with ID and impose $150 fine. This matter was reset to today's date from July 2nd. And I don't need to sign anything on that, correct? Okay. Next matter is City of Yelm versus Donna Linthicum Peasley. This is a matter, Linthicum Peasley is charged with driving the suspended license 3rd degree. The city will make standing motion from the city to amend this to a no valid operating license with ID and $150 penalty. Next matter will be City of Yelm versus Miranda Williams. Come forward, Ms. Williams. Ms. Williams, this is cause number T00494203. You're here on a failure to transfer title within 45 days. Has that been taken care of?
Yeah, I want to transfer it over, but I just don't get it until tomorrow.
Okay. What the city normally does in these situations is they amend this failure to an infraction of expired tabs less than 2 months, and they impose a $150 fine. Is that how you want to resolve it today? Because that's what the city would normally do. They would amend this criminal, because failure to transfer title within 45 days is a criminal event. And what the city does is they amend it to a what I'm going to recommend you do is we're going to amend this to an infraction. You then have the choice to contest it if you so choose. If you just need some more time, if you go contest it and then bring in proof that that you got the title transferred, that's be something we could deal with at a later time. Okay, so we'll amend it to a no tabs less than 2 months, $150, and then you'll get to the window. You can just let them know you want to contest it at the window. Okay, yep. Next matter is City of Yelm versus Donovan Williamson. Am I pronouncing your first name correctly? All right, come and have a seat. Mr. Williamson, this is cause number T00494205. Charges driving suspended license 3rd degree. What the city is going to do in this case is amend the charge to an infraction with a $150 penalty. Okay, so if you go to that form, I'll fill out sign that form in just a second, go to the window to the left, and the clerk will give you that information. All right. And again, if you can get your license back, get your license back. Yeah. Gotcha.
I was gonna say too, are you guys able to like upload my I got tickets that are in information?
I don't, if so long as they're not in the legal aspect, I have no objection. You can let the clerk know I'm okay with lifting those if there's any that are in collection here. Okay, all right, good luck. Okay. All right, City of Yelm versus Janet Funk. Ms. Funk, won't you come forward? Ms. Funk, this is cause number T00487058 on for arraignment. Mr. Haverco, you've been appointed before, so I'm going to appoint you on this matter. There's also a compliance diversion under 6A0021961. So I'll turn over to you for the arraignment.
I think, Your Honor, would stipulate to probable cause that's the court to enter not guilty plea.
All right, Ms. Funk, based on the appointment of counsel and statements of counsel, I'm going to find probable cause for purposes of this hearing only. We're going to enter a plea of not guilty. Ms. Funk, we're going to talk conditions of release here. We now have at least a new charge of theft when you have a pending diversion. The prosecutor had to step out, so he's not here this afternoon. I'm going to release you on your own recognizance. Conditions are going to be law-abiding behavior. Make all court hearings, stay in touch with Mr. Haverco. Madam Clerk, where was this alleged to have occurred?
Yep, phone number.
Okay, was the first one at Walmart too? I don't have it. All right. So no contact with Walmart. Ms. Funk, I just want to make it clear, if we have another case that comes in while these cases are pending, you're going to be held, okay? What's that? You would be held. I'm looking at your record. I'm not sure what's going on. I did see what you're alleged to have taken. If you need assistance with some abuse issues, I suggest you get that taken care of and talk to Mr. Haverco about it. Okay? All right. So we'll give you an out of custody court date. Let's see. Oops. All right, your next court date is going to be August 27th at 10 a.m. So about a month. You're going to be given information on Mr. Haverco. Make sure you stay in touch with him. If you haven't heard from him, reach out to him. Okay? All right, a copy of this will be at the window. Conditions are no law violations. Make all your court hearings and stay out of Walmart. Okay?
Yeah, and I'll be giving you a call. Yeah.
All right, good luck, Ms. Funk. Next case, City versus Franklin Harris. No response.
And
Oh,
and there were two cases, right, for Ms. Funk?
Ms.
There was-
Funk, yeah, she's on a diversion compliance as well.
Right, but there was also a new, say, General.
Yeah, we arraigned her.
Oh,
on
never
the
mind. Yeah,
new
got
theft.
it.
Okay.
I'm with you. Got it. I'm with you.
Next matter, City of Yelm versus Tena Lopez. Come on up, have a seat. Yeah, you can sit right there in the front row. There you go. Am I pronouncing your first name correctly? Tanea, you are Tanea Lopez? All right, Ms. Lopez, this is cause number T 00487062. Charges malicious mischief, third degree. Mr. Haverco, I'll have you do an inquiry.
Okay. Your husband lived too?
I'm not married.
Or you-
Divorced.
I mean, oh, I thought maybe you guys.
No, he's our boyfriend.
I mean, are you part of a household where he has income as well too?
No, he doesn't.
So I also want to get caught, man.
Well, I don't want to talk about the case right now.
Oh.
Yeah.
So it's
So you-
just me.
Make 21 an hour, is about
Are you Mr. Wallace?
42,000 a year, which is about 35.
If this isn't the stage of that, that can be dealt with later.
She grosses about 3,600 a month. And she has a child.
She's disabled and I take care of her.
Okay.
Injured on school.
Okay.
So she has seizures and.
So she takes care of a medically fragile child who has needs. Yeah.
Okay.
So-
Right. What I can do, Ms. Lopez, is I can appoint Mr. Haverco. I would have you pay $150 to offset the costs of the city based on how much you make. Is that something you want to do? Okay. So Mr. Haverco, I'll appoint you again with a $150 contribution from Ms. Lopez to offset the costs of the citizens of the city of Yelm. I'll turn it over to you.
Okay, and pursuant to that, Your Honor, would stipulate to probable cause and ask the court to enter a not guilty plea.
Okay. Ms. Lopez, I'm going to find probable cause for this hearing only and enter a plea of not guilty. As to conditions of release, you're to not to commit criminal law, criminal traffic violations. You appear timely at all court hearings. We'll only use your true name, legal name for court and DOL purposes. We have Mr. Wallace present. I look, this is a malicious mischief charge. Mr. Havercoat, do these folks reside together?
They do. Okay.
I don't know how much I can explain what's going on.
Well, you're gonna have to have Mr. Havercoat tell me, then I'll talk to Mr. Wallace.
Okay. What's the property? Mr. Charged with malicious, okay. You guys reside together? Are you able to continue to live together, or what's the situation? Are you guys broken up, or what's going on?
Does things and then he doesn't do things, and then he says he's committed to changing, not changing. So it's just, I'm taking care of my daughter, I have to literally go to, I just came from a doctor's appointment. And then I have to go break, I have to use to another doctor. Seizure, she's got multiple medication sessions takes, and he's currently gone.
He's at home. He's at home.
He watches her during the summer, but during the rest of the time, we take care of her and make sure she's in school, child care, everything like that.
Yeah, but is the child just yours, or is the child in common between you and him? Just yours biologically?
Yeah, I'm the only one on the birth certificate.
Oh, okay. And are you married to the guy, or you? Okay. Okay.
Same first.
But you guys live together, your boyfriend, girlfriend, or have been? Well, they live together. They're not married, but it's, it's a boyfriend, girlfriend situation. The child is hers, not his. And I guess he got back from being deployed in the military, and there's some issues going on. And so I wonder if it's sufficient to say to not impose a no contact order, but just to order no hostile contact, or.
Mr. Wallace, would you can step forward? And I'm gonna have you stand next to Mr. Havercoat just so the microphone can pick you up. So you're the alleged victim in this case, and obviously I'm not here to talk about what did or didn't happen. I reviewed the police reports. This is a malicious mischief charge. I reviewed what allegedly happened. What are your thoughts on a no contact order?
With the no contact.
No contact order means she doesn't go to if you guys live together, she doesn't go to where you live.
Don't think that's necessary.
Why?
Because, one is I talk with her daughter a lot, and, that would be difficult on her and on her furthermore. Because, what she does, where she can't have her child around, she works from home. So I need to take care of her.
Okay. Do you feel, as we sit here today, I understand this matter this happened back on the 13th of July. Have there been and you guys have been residing since that time?
Yeah.
Do you feel comfortable that whatever's alleged to have occurred on the 13th isn't going to happen again?
Yes. I was coming here today to see what I can do to try and help get it dismissed. I did not realize that this would happen. It
Okay.
wasn't my intent.
All right. Thank you very much. All right. So, Mr. Havercoat, what I will do is this. So, Ms. Lopez, normally in these cases, we'd impose a no contact order. You're out of the house, et cetera, et cetera. Based on the fact that Mr. Wallace is present, he's the alleged victim in this case. Also, I think I'm also looking at your record and lack thereof. I'm willing to impose basically a no hostile contact. What that means is if the police get called, we have a problem. Now, that doesn't mean I'm don't want him to call the police if there's a problem. I don't want you to call the police if there's a problem. But the fact of the matter is you're prohibited from having any hostile contact with Mr. Wallace. Do you understand those conditions? And that's a little bit of a gray area, but I think we know what that means. And Mr. Wallace, you feel that would adequately protect you? Okay. All right. So what I'm gonna do is no hostile contact restriction. Ms. Lopez, you're to appear timely at all court hearings, no criminal law violations. Stay in contact with Mr. Haverco. Does he have a good phone number for you?
I have.
Okay. And give her an out of custody date. August 27th will be the next court date.
You don't need to write it down. It'll be in the paper.
That's at 11 a.m. and you're gonna get a copy of this from the window. All right. Anything else on this matter, Mr. Haverco?
I think that's it.
Okay.
Then I'll
Go ahead and sign the order. And again, there's also an order indicating Ms. Lopez will be ordered to contribute $150 to offset the costs of Mr. Haverco to the city of Yelm. That's all for today. And go grab that at the window, okay? Next case, City versus Andrea Moore. Come in, have a seat, Ms. Moore. This is cause number T00497011. Ms. Moore is present, out of custody. Mr. Haverco, I'll have you do an inquiry.
Okay.
No,
Not at all.
I have social security. Disability.
I have infraction disposition.
I have 19.
Okay.
Okay.
And Your Honor, she receives about $1,900 per month. Social Security.
Okay, any dependents? Okay. Ms. Moore, what I can do is I can appoint Mr. Haverco. I would have you contribute $100 to offset the costs of the city. You do, if you want me to appoint Mr. Haverco. You can hire your own attorney if you'd like. Okay. I'm not gonna have a discussion with this at this point. What I'm doing, Miss. Okay, let me stop you for a second. You're not giving me money. What I'm doing is, based on what you make, the city, you're entitled to a court-appointed attorney, but because of what you make, you're kind of in that gray area. So what I can do is I have two options. I can either say you don't qualify at all, which I don't think is right because you're kind of in that range where I think you do qualify, but I'm willing to appoint Mr. Haverco. But in order to do that, it does cost the citizens of this city money to pay Mr. Haverco. What I'm going to do is if I appoint Mr. Haverco, I'm going to have you contribute $100 to offset the costs to the people of the city of Yelm. Is that what you want to do?
That's the law that.
Is that what you want to do? Is that a yes? It's kind of a yes or no.
Yes.
Okay, thank you. All right, Mr. Haverco, go ahead.
Village public cause, Your Honor, ask the court to enter not guilty plea. Okay. I'll need a phone number. Right here.
You want my phone number?
Yeah, because I'm gonna need to call you and we'll need to talk.
Where do you want me to write it?
Right here by that X. Yeah, because we'll have to talk about your case.
Yeah, we should. It's beautiful.
Okay. This is the order for your next court date, so sign here.
When is that?
They're gonna tell us.
My mother is in hospice and dying, and I'm trying to care for her in Redmond. Could we please delay this as long as possible?
You might be able to appear by Zoom.
I don't use Zoom. I don't trust it.
Okay, Ms. Moore, conditions of release are gonna be a follow. You're gonna be released on your own recognizance. Conditions are gonna be no criminal law violations, stay in touch with Mr. Haverco, make all court hearings. If you have problems making a court hearing, it's very simple. You call Mr. Haverco, Mr. Haverco will convey to us that you have a problem. We're pretty flexible, okay? Next court date is gonna be August 27th at 11 a.m. Yes, yep, we entered a plea of not guilty on your behalf. All right, so Ms. Moore, you're gonna go out the door to the left. There'll be a copy of this at the window.
Yep.
Thank you. All right, next matter, City of Yelm versus April Shippentown. Good afternoon, Ms. Shippentower. This is cause number T 00487063. Ms. Shippentower is present. Charges disorderly conduct to Mr. Haverco.
Yes.
At home?
Yeah.
So receives about $2,000 per month in tribal income and
I'm sorry, how much?
receives about $2,000 per month in some kind of tribal income and has about 4 dependents at home.
Okay. All right. Based on that, I will find Ms. Shippentower is eligible for court-appointed counsel at no cost to her. So we'll proceed. Go ahead, Mr. Haverco.
Thank you, Ryan. Pursuant to that, stipulate to probable cause, ask the court to enter a not guilty plea.
Okay. Ms. Shippentower, based on statements of counsel, I'll find probable cause for purposes of this hearing only, and we're going to enter a plea of not guilty on your behalf. In terms of conditions of release, you have bail posted, is that correct? All right. So going to release you on your own recognizance. Conditions are going to be maintain law-abiding behavior. I'm also going to have you not go back to the Safeway while this is pending. Is that going to be an issue? And you're going to get a copy of this order. So no going back to the Safeway while this is pending, law-abiding behavior, and stay out of trouble, make court dates, stay in touch with Mr. Haverco. Okay? Is that going to work? All right.
Yeah, let's see. You're gonna have to sign here on this electronic pad.
Next court date is going to be September 10th at 11 a.m. All these conditions are in the document, and you can grab a copy at the window. All right. Have a good day, Ms. Shippentower. All right. Next matter, City versus Sydney St. Marie. Good morning, good afternoon, Ms. St. Marie. Cause number T 00494202. Now, Ms. St. Marie, you're charged with driving with suspended license and an operating a motor vehicle without ignition interlock. So that's a bigger issue because you're dealing with not only not having a valid driver's license, but you have a order to not drive without ignition interlock. Okay, so that's why you didn't get the benefit of the deal that we talked about that some of the other folks got. You understand that? Okay. All right, Mr. Haverco, have you do an inquiry?
Court just wants to give him. How much is that? And then the food stamps and all of those.
Yeah, it's under the night food stamps.
She receives $600 per month from in TANF benefits.
Based on that, I'll find her eligible for court-appointed counsel. No cost to her.
And pursuant to that, Your Honor, would stipulate to probable cause as the court to enter not guilty pleas.
All right. Ms. St. Marie, based on statements of counsel, I'm going to find probable cause purpose here and only to both counts and enter pleas of not guilty to both. in terms of conditions of release,
Called, I haven't worked Washington, so that's all.
in Roy.
Yes, yes,
You-
obviously.
Okay. Okay, I was just gonna tell you, you got that warrant.
Yeah.
So, Miss Saint Marie, the biggest issue I see here is you need to quit driving. Okay, and I don't need to know, I'm just telling you, one of the conditions of your release are gonna be, you're not to operate a motor vehicle without valid license and insurance. Not to operate a motor vehicle without, violate any conditions that are on you from DOL, which in this case is ignition interlock. Maintain all your court hearings. I mean, I've held people for less than this on these charges. And I just need you to understand that. Because if you get brought back in here your last one was in February or January. The grace of the city is running out. Okay? Nope, I don't want to hear about the case. Talk to Mr. Haverco. I just want you to get things figured out. Okay, all right. So release our cognizance under those conditions. Out of custody court date, please.
What's that?
If you're gonna get continued.
Oh, from today.
Yeah.
Yeah, then
So then hopefully to make them back,
hopefully, yeah.
have more done with the whole.
Sure.
interlock.
Yeah. That's one, right?
Yes.
Next court date, Miss Saint Marie, is going to be September 10th at 10 a.m. Okay, hopefully you can work with Mr. Haverco and he can help you get your license back and all that kind of good stuff.
Kind of been mainly just the financial part, but I looked into it and found some help.
I got it. Make all court hearings, no criminal law violations, don't drive without valid license and liability insurance, and you're not to operate a motor vehicle that's not in complete compliance with all DOL rules and regulations. Understand that? Okay. All right. We'll see you back here on the 10th. Good luck to you.
Yep. Yeah.
Okay, I'm gonna call a couple other matters. I'll recall Andrea Cheroff. Franklin Harris. Okay, Andrea Cheroff, she's got two DWS thirds on for arraignment. This is cause number T00494197, T00494199. It's now 1:50 and Miss Cheroff was given notice to be here at 1 p.m. for arraignment. We'll go 500 cash or bond on each. Next matter, City of Yelm versus Franklin Harris. Cause number T00508508. Mr. Harris was on for arraignment for hit and run unattended. Mr. Harris was given notice to be here at 1 a.m. or 1 p.m. today for arraignment. Mr. Harris has failed to appear. It's now 1:50. We will go. We'll go 500 cash or bond on that one. All right, Mr. Haverco, I think that concludes the arraignments. Oh, that's it. Unless you want to go deal with Miss, do you want to go assist Miss Moore? Sure. Okay. All right. Anyone here for court who? You're 2 o'clock, 2 o'clock? 1 o'clock, what's your name? Say again? I can't, I'm sorry, you're gonna have to come forward. On the 1 o'clock?
Linthicum Peasley? Oh, okay.
Oh, Lithicum, okay. Oh, yeah, come forward. Miss Linthicum Beasley, Peasley, sorry, I crossed out. So you're charged with driving the suspended license 3rd degree. I ran records this morning and saw that you're still suspended. So you think you're clear? Hold on. Nope, hold on 2 seconds. I can look this up. So Miss Lithicum Peasley, it's still showing you're not licensed. You're eligible. You might have gotten things paid off, but you gotta go pay, you gotta go to DOL and they need to reissue your license.
He said it was lifted.
It's lifted, but you still gotta go back and take an affirmative step to get your license back. So you're not, according to the records I see, you are not licensed yet.
I would like to follow for the vote, please. Because I did.
So Ms. Lithicum Peasley, I'm always gonna tell you, the city made a motion to amend your case to an infraction. No valid operating license with ID, and they imposed it's a $150 fine that you can, that's it. So that's at the window out there to the left. You can go out there and either take care of the $150 fine, but you still have to take affirmative steps to get your license back. Okay, but yeah, the city made the motion because you're close to getting your license. So the city made it an infraction, imposed a $150 penalty, and you'll get the paperwork for that at the window. She'll give you the instructions at the window, but you still got to go to DOL and take some steps to get your license back. Okay, all right. And just, it sounds like the officer's dealing with somebody. You might want to give them a little space till that clears out, but just go ahead and have a seat. Okay, or wait for the window till it's clear. All right. Yep. No, it's okay. Appreciate you coming in. All right, now that you're all done, just go to the window to the left. All right. You can ask him whatever you'd like. Yeah. Okay. Let me see who are you here for 2 o'clock? What's your name?
Jackson.
Okay, and then you're here?
We'll wait 1 second, because I don't know if they're done with court yet.
Yep. We'll deal with that in just a second. And then you're here for the towing case?
Yeah.
Okay. All right, let's deal with Mr.
Oh, a lot of flux.
Yeah,
Oh, okay.
that's it.
Oh,
No warrants? Or no, a couple warrants.
Okay.
There's a couple.
Okay.
All right, Mr. Mann, why don't you come forward? Yep, all right. And you're Jackson Lewis Mann, cause number 6A010936. You're here on a contested hearing for no insurance. Let me get something going here. And I am, you're here for a contested hearing. And what a contested hearing is you're challenging the fact that you committed the infraction. You're not asking, you're not, as opposed to a mitigated hearing where you're saying, okay, I did it, but I want to explain the circumstances.
I was explaining, by the lawyer that.
Go ahead.
I was explaining to the lawyer that this was the best option as it keeps my options open. As I'll get into, I do admit that I was riding without insurance. There's no debate on.
Mitigation hearing. Okay, all right. So I'm looking at your record. This looks like this is your first ticket of this type. Do you agree with that? Okay, so there's a couple options. Without you saying anything else, you're eligible for a deferral if you wanted to, and that wouldn't go on your record per se. And what are we, 4 months or 6 months? 4 months, $100, $150, $100. And what we can do is we can defer it. Is this a non-moving, is non-moving or moving? Non-moving. So you get one deferral, one non-moving, and Mr. Havercall, I'm correct on this, one non-moving, one moving deferral every 7 years. So what we can do is you're eligible for deferral. We get enter the deferral. You don't have any similar violations in the next 4 months. You pay $100. It's dismissed. That's something you're interested in?
Absolutely. Would it change that if I still went through what I was gonna say, or is that probably the best option?
Well, it's probably not going to change much. But it's not going to get worse if you want to say anything. But if you put a lot of time into wanting to say something, I'm fine to listen. But I think I think this is, I think this is a fair option if you want to do it.
Yeah.
Okay, okay, all right. I'll sign that, I'll sign do I have to sign one?
Yeah.
Okay, so I'm gonna sign the order. It'll be a deferral, 4 months, pay $100. Stay out of trouble, dismissed. Okay, thanks for coming in. Okay, and then who do we have online? Seth Garza? Okay, well, there's looks like there's already something agreed. Agreed motion or settling infraction, signed by Garrett. Okay, I'll sign it. Just let him know we signed it. Oop. Okay, so I signed the Garza one, right? Okay. Are you here on the is it Gadam?
Correct, Your Honor, and good afternoon.
Good afternoon. What do we, this is cause number 680263446. Attorney Antonio, is it Gargile?
Gargiulo, Your Honor.
Gargiulo, okay. Mr. Gargiulo, what, we have a failure to stop at an intersection stop sign, and no insurance tickets.
Yes, Your Honor, I do have a couple of preliminary motions. In regards to the no insurance, I can tell the court that my client obtained insurance 10 days after the fact. Does not appear to have it at the time, but as an officer of the court, he did get it shortly thereafter, and so would essentially just be asking to mitigate that count.
Okay.
And I do have some preliminary motions on when the court's ready in regards to the allegation of the stop sign.
Okay, give me 1 second. This is Roble Gidim. Looking at. Okay, and what I'm looking at here is, looks like this is your client's first no insurance type ticket. Looks like he's not eligible for deferral. Does that seem right to you, Mr. Gargill?
That is correct.
Okay, so what I'll do is this. I can knock the no insurance ticket down from $564 to, I'll knock it down to $125.
Thank you, Your Honor.
Right. And then what you said you had a motion on the failure to stop at the intersection?
Yeah, I have a couple of potential motions. I'll start with we'll kind of go from there, but as I'm sure Your Honor is well aware, the general principle that when there is a specific statute, the city or state has to cite the specific over the general. That's a well-known principle of case laws borne out in State v. Shriner on a criminal aspect, and then also reiterated in Re Estate of Black in a civil context. But generally, the proposition is that the prosecuting authority has to cite to the specific statute over the general or nothing at all. This is cited under RCW 4661-200. I would argue that the proper citation is RCW 4661-190. That is the specific statute governing a driver's conduct when approaching a stop sign. It specifies both the duty to stop and the precise location where the stop action must occur. 200 is more of a general enabling statute authorizing governmental authorities to designate locations for stop signs. So clearly the 46-61-190 is the more applicable statute, and is what should have been cited. Obviously, the city has chosen not to appear on these, contested infractions. They theoretically would have the ability to amend it if somebody was here from the city, but given that they're not, I would essentially be asking that this be found not committed due to the fact that it does not cite to the specific statute.
So I'm looking at 46-61-200. And it states, if you go through, it talks about points of intersection, any public highway within an arterial public highway. This was at 510 alternate and Killian Avenue in Yelm. And the last section says, it is unlawful for any person operating any vehicle when entering any intersection determined, designated, and bearing the required sign to fail and neglect to bring the vehicle to a complete stop before entering the intersection, except as provided in 46-61-190, which you're saying 46-61-190 would be the more appropriate RCW, correct?
Correct, Your Honor, because you can theoretically violate 200 and not violate 190.
Right.
And 190 is the exception that is outlined in 200.
And 46-61-190 talks about preferential right-of-way, authorized flagger, police officer.
It's the portion where it talks about the stop lines, marked crosswalks, marked stop lines. So it gives the
which part of 46-61-190 do you think is what it should have been cited under?
Well, I think it should be, generally you see it under 2A. Let me pull, I was under 2. Give me, I believe it's 2A. That one.
Because 2A talks about someone then directed to proceed by a duly authorized flagger, police officer, firefighter. So there's some reason an intersection is controlled by certain individuals. Section B1 talks.
Well, it says sorry to interrupt, Your Honor. It says except when directed by, right? So all those special people that have if they're directing traffic, for example, it says every driver of a vehicle approaching a stop sign shall stop except as provided by B of this subsection at a clearly marked stop line, but if none before entering a marked crosswalk on the near side of the intersection, or if none, then at a point nearest. And so that's what 200 is saying, is giving the exemptions of just saying, yeah, we generally have to stop for stop signs, but if there's a stop line, you stop for the stop line as opposed to the stop sign. So 2A is talking about except when authorized flagger, police officer, firefighter, and then it talks about the stop sign itself. And where specifically you are supposed to stop, where 200 is just basically, yeah, the governing authority can establish stop signs and you have to stop for them. But 190 tells us exactly where you're supposed to stop for them.
All right. Yeah, I'm gonna, Mr. Gargill, I'm gonna deny your motion. I don't agree that 46-61-190 is the I think maybe he could have been cited under 46-61-190, but my reading of these two statutes, particular 46-61-200, talks about, and I'm quoting from 46-61-200, it says it is unlawful for any person operating any vehicle when entering any intersection determined, designated, and bearing the required sign to fail and neglect to bring the vehicle to a complete stop before entering the intersection. Now, it then does say except as provided in 46-61.190, which the exceptions in 46-61-190 talk about right of way, but then they also talk about how right of way applies except when directed to proceed by a duly authorized flagger or police officer or firefighter vested by law with authority to direct, control, or regulate traffic. So I do think 4661-200 is the appropriate RCW to cite in this case. So I'll deny your motion challenging the adequacy, I guess, of the citing RCW.
Understood, and I would note my objection for the record respectfully, Your Honor, but the problem is that under 200, my client very well could have stopped for a stop line, and that would not be a violation. And that's why 200 is not the more appropriate.
Well, but I'm reading, if I read the,
I think,
go ahead.
I was going to say my second motion, which I think gets back potentially is a problem with the no insurance, is RCW 5.50050, which says that the court, the infraction rules of limited jurisdiction say that the court can consider the notice of infraction. The notice of infraction is a one-page document that lists out all the information, and then any other document under the penalty of perjury. Problem with that, what is required to make a document under the penalty of perjury? And if the document under the penalty of perjury, the court by the rules cannot consider it. The issue here is that there is no agency on this signature line, which is a requirement under the definitions of a valid signature. There's no agency that you can logically associate with.
Hold on one second.
And
So
with that,
hold on one second. So now so the motion is to challenge the admissibility of the officer's report based on the general rule related to signatures and electronic signatures?
correct.
Okay. And your argument is that Officer Mooney did not indicate the agency?
An agency is required to have a valid signature under 5.50050. Now, when you go to the definitions of what a valid signature is, valid signature requires.
And I'm familiar with that RCW. So I'm looking at this report. And do you, and I don't want to belabor this issue, but so we have Officer Mooney's signature under penalty of perjury on page 1 of the report, which indicates YMP number 3972. And then we have on page 2, we have signature Brian Mooney without the YMP, with badge number, I assume 3972. Is it your position then that the YMP on page 1, assuming that's adequate to identify the agency, would that not be something I could consider when looking at the document as a whole? Because they're both under penalty of perjury. So what are your thoughts on that? We lost connection there for a second. So did you hear my question on that?
Yeah, and I apologize about that. I think the whether the YM is sufficient.
Yeah, Officer Mooney clearly indicates his name, says YMP, which I feel like I can take judicial notice as Yelm Municipal Police Department. Badge number 3972, and that's on page 1 of the document. And then on page 2, it's again under penalty of perjury. And it says Brian Mooney, the YMP is missing, but he does have 3972.
So two things, Your Honor. One, the YMP, I would argue that you cannot take judicial notice. I mean, we have two people in that courtroom today that look like pro se individuals. I'm sure they do not know what YMP stands for. To take judicial notice of something, it has to be readily known within the jurisdiction. I would argue, as obviously trained legal professionals, what I know and what the court may know stands for something is not something that is able to take judicial notice of, because the general public would have no idea what that means. The second issue is that page 1 of this document is admissible per the rules. No problem with that. The problem is page 2, that is, there's a few issues that become a problem by trying to, it's not under the penalty of perjury because it lacks a valid signature. And without a valid signature, it is not a document that can be considered under the penalty of perjury because it lacks the form and substance to make it so. There is no agency on page 2. And if they are trying to claim the incorporation, it's on the city to establish that incorporation. To incorporate something by reference, it needs to be clear and unequivocal and in existence at the time the original document was created. The original document is a one-page report that is handed to my client at the time of the stop. And so if the city wants to try to even, I would argue that the YMP is not something that the court can take judicial notice of per case law on what is considered available to take judicial notice of, but it's clearly not on page 2. And if they want to try to rely on that, it's their burden to establish that that report was in existence when that ticket was handed to my client, which I don't think they can do today. And I would note that it's obviously something that's been fixed, because in Trax system, which has replaced Sector, it lists the agency of these officers. So we don't go back and fix something if it wasn't an issue at the time that we're doing this through Sector, but as we're moving to Trax, they always have the agency on it. And that's because it has to have that to comply with the RCW.
So let me make sure I'm just understanding. Are you saying something was changed?
In the new track system that a lot of the law enforcement agencies are I believe it's moving statewide, slowly rolling out. But it's the T numbers that has the agency inserted in when the officer signs it and submits it under that system.
So the copy of the office, so I have a copy of the contested infraction notice that was submitted by your client, and on the bottom of that it says Officer Brian Mooney, YMP number 3972.
Yeah, I have no problem with that, but I think YMP is not, I have no problem with the admissibility of that ticket. That is admissible per the infraction rules of limited jurisdiction.
Mm-hmm. But your position is that the narrative is not.
The narrative is not, because it's not sworn to.
Well, isn't it under 5.50.010? Wouldn't this signature line be electronically valid under the RCW?
No.
Why not?
Because it doesn't meet the requirements of what law enforcement officers are required to do to have a valid signature. So
what are those requirements? Is that, we are right? It's 5.50.010, right?
Yeah. So it's so 5.5050 talks about, okay, what do we need? We need an unsworn declaration under this chapter, maybe substantially in the following form. declare under the penalty of perjury on the laws of the state of Washington, had that signed on date, place, promise the signature. And so when you go to 010, the definition section, 5.50010 to sign. So 3E, to affix or logically associate the declarant's full name, department or agency, and badge or personnel number to any record that is electronically submitted to a court, prosecutor, magistrate from an electronic device that is owned, issued, or maintained by a criminal justice agency. That is the only way to sign, because if you read it any other way, then you're making subsection E superfluous. And we don't make read things to make things redundant or meaningless. So E is plain on its face that a law enforcement agency, when they are trying to sign something through a electronic device that is owned and maintained by a criminal justice agency, which sector is, this is how they have to sign their name to have a valid signature. Without a valid signature, it's not properly sworn to. If it's not properly sworn to, take it back one step, it's not admissible.
Okay, so is it your position then that had Officer Mooney on the narrative side, put Brian Mooney, Yelm Police Department, number 3972, would that have been a valid signature under 5.50.010?
Yes.
If Brian Mooney, Officer Mooney would have put Brian Mooney, comma, YMP, number 3972, your opinion is that's not sufficient?
I would argue that it's not sufficient. I don't think that is something that the LE, I think it's what is it, LEA or LEO code that LEA, I'm sorry, code that is associated with a particular law enforcement office is not something that is readily available and known within the jurisdiction.
So I'm looking at jabs right now. For example, this ticket, the case number is 6A0263446 YMP. The court is Yelm Municipal Court. And then just for comparison purposes, your client has another infraction, T blah, blah, blah. And the citing agency in that case was WSP, which is, would I be entitled to take judicial notice of WSP?
It's an argument to make, because WSP, I think an argument from a reasonable argument to assume that that's Washington State Patrol. YMT, I would argue, is not something that's readily known. I mean, WSP is what they go by.
All right.
Anything
else, Mr.
Yeah,
Gargo?
I would just, the only thing I would also note is like obviously we have these tickets itself. I was down in Thurston County today and I had a Olympia Muni case in Thurston County District Court. The general public does not know the law enforcement agency. Trained legal professionals do, but it's not, the standard is not what does a trained legal professional know? It's what the general public to take judicial notice of something.
But it's not only, I mean, I use the term judicial notice, but also it's taking the position that YMP is not sufficient to identify the law enforcement agency.
And I don't believe the city is appearing on these cases.
They're not. They're not. I'm just trying to figure out to make sure I understand the argument, because I'm struggling, and I've dealt with this issue many times. I'll be honest, I do think YMP is sufficient to identify the agency. I think the question becomes whether or not YMP needs to be specifically put on the signature line as it relates to the narrative. Because I will agree that the narrative does have its own declaration. And so the question, I think, is whether or not I can integrate page 1 of this document with page 2. I've seen judges go both ways on that. Judge Wilcox in Thurston County will do that. I think Judge Meyer in Thurston County won't do that. So your argument is I shouldn't do that.
But I mean, just per I mean, I don't think the court can incorporate. The city can incorporate. Well, it's the city's burden to incorporate, and to incorporate something by reference, it has to be clear and unequivocal, and has to be in existence at the time that the original document was created. There is no testimony today establishing that page 2 was done at this when that ticket was given to my client.
Okay. All right. I think I've heard enough. So I think I disagree with you as it relates to the court's ability to integrate documents. I don't think I'm limited to, I don't think myself or any other court is necessarily limited to, looking at page 1 in a vacuum, page 2 in a vacuum. I will,
and before the court rules, would the court consider allowing me to talk to a city to decide if they want to negotiate this instead of dealing with something at an appellate level?
yeah, I'd be willing to do that. If you want to kick this a month and talk to Mr. Ratfield.
Okay, I can do that.
Okay, so we've resolved the, and I understand your argument. I just don't, I just don't necessarily agree with it in its entirety. Maybe you can convince Mr. Ratfield and that would be different, but I think that makes sense. If we've resolved the no insurance ticket. So that one will be taken.
Is it possible just so we don't bifurcate them, just as, I mean, it's not going to change the fact if he had insurance now or, he had it after the fact, instead of bifurcating, can we just kick over the whole thing?
That's fine. We can kick them both. All right, Madam Clerk.
Okay.
We'll kick them both 30 days. Let you talk to Mr. Ratfield about options and we'll go from there.
Okay. Thank you very much.
Thank you.
Take care.
Yeah, you too. All right. Towing. Is Mr. Johnson going to be here? Mr. Johnson's the owner of the vehicle. So the problem we have is you don't have standing to really make an argument because you're not the registered owner of the vehicle. But then he needs to come in here and say, I'm in jail. And,
There's a April 19, this case. The legal owner of that vehicle was Patricia Butler. And they didn't recently get the vehicle in their name until May 7th after the fact. The vehicle was in.
okay. Well, are you Miss Belker?
No, he's equal there, that's part-time, it took us months in order for them to knock on the door after day, just to have them sign a release. We could not get in touch with them. I mean, what it took was the car to get impounded, for us to call and say the car is impounded, we need to get it out of there, or it's gonna go on your bill, your ticket. We finally got a hold of it. It took us months to get a hold of these people after we did nothing. Get this car out of their yard and another car because they were having, issues with the owner. And so it took a long time just to be able to get a hold of these people after they did this vehicle. So that is not our fault. And then I didn't get it because it was not mine, and they had, it was to John. So he had to go down there. And so, and actually, the owner of the vehicle, they said that they just called me and he went down there. He didn't have to go with them to go to the department, but he to get it changed over. So I'm sorry to see you, I'm sorry that you did that. And
Yeah.
I'm sorry that you did that to the car. If my knowledge, I used to have a 12-hour notice on the car. The car was not in the road.
Hold on a second. So,
So it took me, forever.
I know, but let me stop you for a second. So I have evidence in front of me that on its face indicates to me that the tow was proper. Okay? We don't have the registered owner. Because you're not challenging the validity of the tow, you're challenging who can argue it or who can do this or who can do that. I'm here to address whether or not the impound was justified or not justified. And is it your position that the tow was not justified?
Saying that you picked up the car and moved it to the road you're on.
Who's they?
Them.
The police?
Yes. You go, I'll be out the back seat of the.
Okay, all right, I'm gonna stop you. I know, I'm gonna stop. I'm gonna stop you. Okay, all right. I'm gonna rule on what I have here. I don't think, what's your name, by the way? Polly Parks? Okay, Miss Parks. You're not a registered owner, were the registered owner. I don't have any sort of authority for you to be here on behalf of Mr. Johnson. I have before me the record, which constitutes an incident report. In that incident report, there was a vehicle that was left. This is by Officer Armstrong, who's present. The vehicle was left in the northbound lane of Bridge Road Southeast. I'm familiar with Bridge Road Southeast. It's a narrow road. I don't think there's a center line. I attempted to obtain the registered owner's phone number, but was unsuccessful. The review of the vehicle's history showed that Cassandra Williams had been driving it each time it was stopped. Officer tried to contact her contact information. At this point, I advised dispatch. So it looks like the officer did many things to try to avoid towing this car. Too Cool Towing was contacted, the vehicle was towed. And then subsequently, this appeal was filed. Do you have evidence of something?
They said they didn't have it, because they are just a little off, and it was not in the road on, it was not, yes, the first report.
Okay, did you, why don't you come forward? And just, you please, this is, nope, right there, on the side there. To the microphone side, right here. Yeah, there's a microphone right there, I see it over here. This is, cause number BH 26-001, regarding the towing of a vehicle. Petitioner in this case was John Johnson. Please identify your name for the record, please.
My name is Colleen Parks.
Tommy?
Colleen.
Colleen Parks. All right, Ms. Parks. Raise your right hand. Raise your right hand. You left. Right.
I'm sorry.
You swear or affirm the information you're going to provide is truth, whole truth, nothing but the truth?
I swear.
Okay. What do you know about, and I've read into the record, the police report I have as to Officer Armstrong's efforts in this case. The information I have is this vehicle was parked in a roadway, obstructing traffic to some degree. Officer tried to find the registered owner, tried to find other alleged drivers of that vehicle, was unsuccessful. The decision was made to tow. What information do you have about this case that you think is relevant?
All I know is I know that I did not park the car in the road. I did not even have it on the road, Your Honor. It was on the grass. They said that it was in front of a house and there was no trespassing signs in the area where I was parked. That there is a field there where I parked the car, Your Honor, because I ran it. I was only gone for maybe 2 hours trying to get gas. I came back and the car was gone. I thought somebody stole it. So, and I had called the impound or I got the police, that was on, case, I don't know what, I called 911 and they gave me the number of the officer that impounded it. And he said that it was in the road and it was blocking the house and the driveway. And I went to the neighbors that live, and they have cameras and everything. And they said that they can't produce the film.
Okay. All right. Anything else? Are you challenging the costs of the tow or anything like that?
My daughter paid for it. She
Okay.
helped us pay for it.
So that's a no. Oh. Say again? Yeah, but I'm not hearing her. I just asked, that's why I asked her the question. All right. So you didn't pay for it. You're not challenging the fees or anything like that?
No, I am. Because it was.
Do you have any information on what basis are you challenging the fees?
They had no right to tow it. They picked it up and moved it out into the road.
I understand you're challenging the validity of the tow. That's one issue.
I might need to get the money back from my daughter. It's my daughter's money.
Anything else?
No.
Okay, all right. At this time, based on the evidence that I have before me, which consists of the report as well as the operator official fee scale that is part of this process under the statute, I'm going to find, number one, that the tow in this case was justified. I'm also going to find that the fees were reasonable, and I'm going to deny the appeal.
Thank you, Your Honor.
Thank you.